Hello, everybody. Hi. Good to see you all. You better bring that beard. I love. So happy you're here. Oh my goodness. Hi, CE. How you doing, sweetie? Hi, Andrea Collins. Here it is. Your insufferable host has arrived. Hi, honey. How you doing? Good to see you. Hi, Tammy. Happy birthday, Alexia. Ooh, that would not have been good. No bueno. Hello, love. Yes, darling. They're on Discord and Reddit. But the paw firm, there's a big difference, Philippines. Hello, Ava. Your audience is awaiting. They missed you. Give them that love. Give them that look. She's like, yeah, Mom, just pet. Just give the scritches. Stop the drama. Aww. Come on, mouse. Work. My mouse doesn't want to work. Right there it is. Everything you need in here. Because there's paw puppies and paw kitties. Right, Earl? Earl has been very vocal until I want him to be. He scared me earlier today, but I learned what it was. So my daughter was home for the 2 weeks with that, with her infection. And today Earl was just standing outside of her door, very loudly crying, like round, round, repeatedly. He just missed his mama. That's all it was. They are the best, aren't they? Bestie Estiestes. Guys, Karma was drunk today. I'm convinced of it. 100%. Yep. She was drunk. Because every time I was doing something good, the opposite of rewarded happened. Like, tremendously. So, Backpack that used to stay here, he had gotten a ticket and then had upped and moved away. Well, today the ticket was due, and he asked if he could cash at me the amount needed for the ticket to go pay it. And I was like, okay, sure. The courthouse is only a few blocks from my house, whatever. It's like negative 20 some degrees this afternoon. And I go to start my Jeep and my tires are low. I'm talking, they were down to like 20 PSI when they're supposed to be 40. So I had to put it in. And it wasn't because anything I did. It was because it was freaking negative 15 to 20 degrees today. So thank God one of my best friends had given me a couple of years ago one of those tire blow-upper thingies that you plug into your cigarette lighter. They take forever, but hell, they work a hell of a lot better than the gas station pumps. So I got all of them pumped up, and I went and I took care of his ticket, and I stopped at the gas station to get some bread, and the cashier was like, man, have y'all had to work with this new cab company yet? I have, because I had tried to set up rides for my neighbor a few times, and maybe it's just growing pains. Maybe it's that the company sucks. I'm leaning on the latter. Like you can't say I need a cab at 2:30. You have to give them a half-hour block of time of I need a cab between 2 and 2:30. So, and every person has to have an account, period. Like, you can't just say, pick me up at Walmart and take me to the hardware store. No, nope. You have to have an account. So all of these bartenders and cashiers, grocery store workers that are calling cabs for people, they can't just call it anymore. They have to create an account for this person. That's going to be awesome. Yeah. And so anyways, I told her without going into a ton of detail, I just told her, yeah, they take a long time. They don't do instant rides anymore. And so it's going to be like an hour. She's like, well, I've been on hold for 15 minutes. I'm like, then plan on an hour and a half. She's like, oh, great. So I'm looking around, and it's all like older people in the store. And I'm like, who needs the ride? And she's like, the gentleman that's over there at the counter. And the guy had to have been like 80, y'all. There was nothing to him. He was like skin and bones. And he had a Philip Heels beard. And I was like, nah. I was like, hang up. I'm going to give him a ride. So I went up to him and I'm like, sir, it's going to be like an hour and a half till the cab comes and gets you. You want to trust me and just get in my Jeep? And he was okay with it. He got in my Jeep and I gave him a ride. It was like a mile and a half. No big deal. And he was so super grateful. But on the ride, my daughter calls me. She says, Mom, the oven broke. What do you mean the oven broke? The door fell off. How did the door fall off? Well, the handle fell off and then the door fell off. Don't touch it. I got home. Like the screw and the washer that's like that holds the handle, it also like presses the three pieces of oven door and glass and metal all together. And that when the screw came out for the handle, the whole thing just collapsed. But I put it back together. I screwed it all back together. Boom. Oven's fixed. But it was fun. It was a fun day. Hi, Aiden. Yes, second time. I know, but it's all right. You know what? At least it was fixable stuff. You know? Nothing's perma broke. The tires have air. The oven has door. It's okay. Is that what it's called? Okay. You're lucky I got PSI right. I don't know. He reminded me of you. Maybe that's one of the only reasons I trusted him. He didn't have the accent, though. But he had a case of Keystone. Oh, Philip's starting out strong. Thank you, honey. Thank you so much. I love you, and I so appreciate you. Yes, that like button. Oh, I really appreciate that. Thank you. I work really hard to try to find a variety. Speaking of which, y'all, I don't know how long y'all want to hang out with me tonight, but I found a brand new judge in a brand new state. I don't know if anywhere else has ever covered the state, but I've never seen it. And I love the judge. He is a crabby, old, sarcastic man. My favorite. Yes. Yes, yes, yes. We're going to start off, though, with the thumbnail clip because the crabby old man docket. I clipped almost all of it, and it started out around 3 hours. And, well, no, about 3.5. And I clipped it down to 2.5. So, yeah. But I was less aggressive on cutting out every single breath. The girls told me that I didn't have to. So I let the breaths stay in. I know. Thank you for your comment, Emily. Hi, Lizette. I'm so happy you're here. No. Just hit the like button before you do, and then you can just let it run while you sleep. And I don't have any yet, but I will be going and getting my coffee. I did not plan well for my time. That's why my hair is still wet. I'm lucky I'm wearing clothes. When? What? What? I'm so confused. I definitely did not. Not to you, anyways. Not yet. The whole chat's scrolling back real quick. I swear I didn't do it. It wasn't me. Chadaskadom, I'm so happy you're back, my love. It's so good to see you for real. Honey, I missed you. I'm so happy you're here. Oh, breaths. Not breasts, breaths. Like breathing breaths. What do you expect? Checks and cherries? Oh, my stomach hurts already. We're not even 20 minutes into this thing, and my stomach hurts from laughing, y'all. Oh man, this one's on you. This one's on you. Oh, okay. Oh, wow. I'm going to put the clip on, and then I'm going to go get some coffee and a Kleenex. Ooh. Ooh, I need some breaths. I gotta enunciate that word.
Childs, he's here for a pretrial conference. Court's been advised that this is going to be a plea. Is that correct, Mr. Price?
It is, Judge. I reviewed the advice and rights with Mr. Castleberry. He's signed it, Judge. He doesn't tell you that.
Is that correct, Mr. Childs?
Yeah.
All right, would you raise your right hand, please? You solemnly swear or oath to affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. And Mr. Stay, would you put your plea agreement on the record, please?
Defendant will enter a guilty plea to count 1, operating while intoxicated. Third offense, the people move to dismiss count 2. The people calculate the guidelines at 0 to 6 months on minimum. People will cap at 90 days.
Mr. Price, has the prosecutor accurately stated the plea agreement in this case?
Yes, Judge.
Is that the agreement that you reached, Mr. Childs?
Yes.
Okay, so the charge that you're entering a guilty plea to reads as follows: that on or about November 3rd, 2023, that you were in Big Prairie Township, Durango County, state of Michigan, that you committed the crime of operating while intoxicated. Third offense, that you did operate a motor vehicle on East 36th Street while either under the influence of alcoholic liquor or having a bodily alcohol content of 0.08 grams or more per 100 milliliters of blood. If charged this as a third offense, they've alleged that you have at least 2 prior drinking and driving convictions. They've listed here as operating while impaired July 28th, 1993 in the Allegan County District Court. Do you have that prior conviction, sir?
Yes, I do.
Operating while impaired March 23rd, 1992 in Montcalm County District Court. Do you have that conviction as well?
Yes.
Therefore, upon conviction, you will be subject to an enhanced sentence, which could include vehicle forfeiture, a fine of not less than $500, no more than $5,000, either 1 year to 5 years in prison, or probation with 30 days to 1 year in jail, at least 48 hours to be served consecutive, and 60 to 180 days community service. I can order rehabilitative programs, cost of prosecution, reimbursement to the government for emergency response. Vehicle immobilization is mandatory of not less than 1 year, no more than 3 years. You understand the charge, the maximum penalty?
Excuse me?
You understand the charge
Yes,
and the
sir.
maximum penalty?
Yes.
All right. Now, there's an agreement, sentencing agreement in this case, that you be sentenced consistent with the advisory guidelines. The prosecutor score goes 0 to 6 months, as long as 90 days falls within the guidelines. As I score them at the time of sentencing, you have an agreement that any upfront jail time would not exceed 90 days. Do you understand that?
Yes,
You'd also be consenting to a term of probation. Do you understand that?
yes,
Is that your complete understanding of the plea agreement in this case?
yes.
Have you had sufficient time to consult with Mr. Prysack about your charges and this plea agreement?
On the phone. We have talked.
Okay. Was it enough time to talk?
I believe so.
Okay. As subject to the plea agreement, how do you wish to plead?
Guilty.
Do you understand that if I accept your guilty plea, you're giving up your right to have a trial of any kind?
Yes,
You also understand that you're giving up certain constitutional rights and other rights you would have if you went to a trial.
yes,
We've listed those rights for you on the written advice and right sheet that you signed today. Did you read that document?
yes,
Did you understand those rights?
yes.
Has anyone threatened you to get you to make this plea?
No,
Has anyone promised you an outcome different than what we put on the record?
no,
Are you entering this plea of your own free will?
yes,
You understand that if I accept your guilty plea, you're giving up the right to later claim that this plea was not your choice, or that it was a result of any promises, threats, or inducements which are not disclosed to me today.
yes,
You understand that I'm not bound by this plea agreement, but if I don't go along with it, you can withdraw your plea.
yes,
If you now give up your right to have a trial of any kind, and all the constitutional rights and other rights that you would have at that trial, then do you affirm your guilty plea?
yes,
Is it true that on or about November 3rd, 2023, that you were in Big Prairie Township, Nuevo County, state of Michigan?
sir.
Were you operating a motor vehicle on East 36th Street?
Yes,
Whose vehicle was it?
my wife's.
Had you been consuming alcoholic beverages before driving?
Yes,
What were you drinking?
beer.
How much beer did you have?
I'm not really sure how many I had. At least, probably 6 or more.
Over what period of time?
That was within a few hours
Where were you doing this drinking?
at a friend's house.
Were you feeling the effects of the alcohol that you consumed?
Yeah, it was.
You think that your ability to drive was significantly and materially affected due to the consumption of alcohol?
I know I shouldn't have been driving.
You think it was affecting your ability to drive?
Yeah,
Did you take a blood test?
yes, I did.
Do you know the results of that?
Yes, it was 0.14 or something, I believe.
You accept that that was an accurate reading of your bodily alcohol content?
Yes,
And you previously indicated to the court that you have at least 2 prior impaired driving, is that right?
yes, I did.
Do you have any other criminal charges on your record? Your last conviction for anything criminal was back in 1993.
Excuse me?
Your last conviction for a crime was in 1993.
No, I do have driving on suspended.
How many of those?
I have 2, maybe
Okay.
3.
Any other criminal offenses?
I have, I believe it's a drunken disorderly.
It's been a while, Judge. He's had his last impaired was in 23 or 93, so 30 years ago. The license suspended was as well 30 years ago, and the other one was 26 years ago, so he hasn't been in any trouble for quite some time, so may not specifically remember, Judge, but it's been quite a while.
Yeah, I guess I was trying to figure out why you wouldn't consider sobriety. And I was trying to figure out if there was some conviction that he had that would prohibit him from going into it.
Yeah, that's true.
It's not right. You get 30 days in jail. You get 30 days in jail.
Is it 30 now, Judge? Okay, so it's 30 days. in jail. Judge, that's something that you might consider now that you mention it. And possibly if I could get the information from Mr. Stay, and maybe if we could adjourn, and then I can meet with Mr. Childs, and we can discuss the possibility of sobriety court. He does work full-time. He's been in his work position for 17 years.
Just over 17 years.
What do you do, sir?
I drive an order picker for Wolverine Worldwide.
What kind of picker?
An order picker, it's a stand-up forklift,
Oh, okay. What do they pay you an hour there?
$20.30.
Why'd you ask the court for a court-appointed attorney? You're making $20 an hour.
Oh,
It was offered.
so you don't do that.
Well, are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
Are we doing the plea or the adjournment?
I'm not adjourned. I took his plea.
Okay.
No, Your Honor.
So how much do you want to bet that if the guy hadn't taken advantage of Newaygo County and taken a public defender when he clearly makes enough to afford hiring an attorney, how much do you want to bet that the judge would have been more lenient with him and adjourned his case out so that he could do sobriety court? And I bet if he had taken his private attorney in the first place, he wouldn't have been so bogged down with cases that he'd have overlooked the option of sobriety court. The guy would have made out much better if he had hired his own attorney.
Or none, Judge.
Is the defendant competent to enter this plea?
Yes.
Yes, Judge.
Does the court comply with the MCR 6.302?
Yeah.
Court has.
Right, the court does accept the plea. Do you find it familiar, statement voluntary and accurate? I'm going to refer him to the probation department for the preparation of the pre-sentence investigation report. I'll set sentencing for January 30th at 9:10. If he's interested in sobriety court, he can follow through, and if we have a recommendation or an acceptance before sentencing, we can deal with it at that point.
You say January 30th, Judge?
I did.
Thank you.
Oh, there we go.
This is case number 23-13240 FH, People versus Robert Lee Smith III. We're sent here for a final conference. And Mr. Stay, is there a final offer that you're making?
For the defendant to enter a guilty plea to count 3, the people move to dismiss the balance of the information. People calculate
Yes.
guidelines at 0 to 17 months on the minimum. The people would cap at 9 months.
Robert, as we talk, when I told you I talked with the prosecutor, he's dismissing everything but count 3, which is the possession of a Kenneman.
So it's just count 3 now?
Pardon me?
Did you say it's just count 3?
Just count 3, the possession of a Kenneman, is dismissing all the other charges.
Okay, are we doing time served or?
Well, we'll get the sentencing date set, but it's the same deal as before, 9-month cap, but he's only one charge.
Okay, you guys, get ready to meet the most ungrateful defendant we've seen in a while, the most unremorseful defendant that we've seen probably ever. No remorse, none. Pitchforks and fire, y'all.
Okay? Judge, I reviewed the advice of rights with him and he authorized me to sign for it, so.
You want to enter a plea of guilty today, Mr. Smith?
Yes, sir.
Raise your right hand, please. Do solemnly swear, oath, or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth throughout the gap?
I do.
So the charge that you're entering a guilty plea to reads as follows: that on or about January 30th, 2023, that you were in the city of Newaygo, county of Newaygo, state of Michigan, and that you did knowingly or intentionally possess ketamine. Now, this is a felony which carries up to 2 years in prison and/or $2,000 fine plus cost. Do you understand count 3 and the maximum penalty?
I do.
In exchange for your guilty plea to count 3, they're dismissing the 4-year felony possession of morphine, the 4-year felony possession of hydromorphone, And they're also dismissing the potential of a double drug enhancement. Is that your understanding of how the charges are being resolved?
It is.
You also have a sentencing agreement, number one, that you be sentenced consistent with the advisory guidelines. Prosecutor scored those at 0 to 17 months, as long as 9 months falls within the range of guidelines. As I scored them at the time of sentencing, you have an agreement that any upfront jail time would not exceed 9 months. Do you understand that?
Yep.
You would also be consenting to a term of probation. You understand that?
Yeah.
Is that your complete understanding of the plea agreement in this case?
I guess, yes.
Subject to the plea agreement, how do you wish to plead?
Guilty?
You understand that if I accept your guilty plea, that you're giving up your right to have a trial of any kind.
I do.
You also understand that you're giving up certain constitutional rights and other rights that you would have at that trial.
I do.
We've advised you of those rights in writing. Did you go over those rights with your attorney?
I did.
Did he read them to you?
Yes,
Did you understand them?
I did.
Do you have any questions about the constitutional rights that you're giving up by entering this guilty plea today?
No, I don't.
Has anyone threatened you to get you to make this plea?
No, sir.
Has anyone promised you an outcome different than what we put on the record?
No, sir.
Are you entering this plea of your own free will?
I am.
You understand that if I accept your guilty plea, you're giving up the right to later claim that this plea was not your choice, or that it was the result of any promises, threats, or inducements which are not disclosed to me today.
Yes.
Do you understand that I'm not bound by this plea agreement, but if I don't go along with it, you can withdraw your plea?
Yes, sir.
Do you now give up your right to have a trial of any kind, and all the constitutional rights and other rights that you would have at that trial? And do you affirm your guilty plea?
I do.
Are you pleading guilty because you are guilty, or is there some other reason for offering this plea today?
Plead guilty because I am guilty.
Is it true then that back on January 30th of 2023, that you were in the city of Newaygo, county of Newaygo, state of Michigan?
Yes,
Did you have some encounter with the police?
I did.
Was this a traffic stop or what happened?
I was leaving a gas station and a cop pulled in front of me and turned his lights on. I was in the parking lot.
Okay. And as a result of that police encounter, did they find some ketamine?
Yes, they found a ketamine in the vehicle that,
Was it your ketamine?
yes, sir.
And a whole slew of other pharmaceuticals. If you missed it, among them were morphine and hydromorphone. And he got the other ones dropped along with an enhancer and got it knocked down to just that one. He got the gift of a lifetime. Let's see how much he appreciates it.
How much did you have?
I think it was just 1 or 2 capsules of the ketamine.
Where was it located?
In a pill bottle inside the glove box or right there.
And you didn't have a prescription for that, did you?
No, sir.
All right. Are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
No, Your Honor.
They're not,
Is the defendant competent to enter this plea?
Yes.
yes, Judge,
Does the court comply with MCR 6.302?
Yes, Your Honor.
or that.
All right, the court does accept the plea. I do find it to be knowing, understanding, voluntary, and accurate. I will set this case for sentencing January 30th at 9:20 a.m. And Mr. Smith, you do have the right to be personally present for that sentencing. or you can waive your presence at the sentencing. We can do it remotely. Have you discussed those options with Mr. Prysock?
Not yet, but it was my understanding that sentencing would be pushed out at least 8 weeks.
Set sentencing for January 30th.
It's about 7 weeks.
Okay, okay.
So do you want them, do you want them to bring you here, or do you want to do it remotely?
I'll just do it remotely.
Okay, all right. All right, that's all for today.
I'll call you and we'll,
Judge,
Yes, sir.
I was gonna ask, I'm trying to bond out of here, so I revoked my own bond from there since I've been arrested, but I'm asking the court to do a personal recognizance bond on this charge so I can try to bond out of my charges here. Since I already have 6 months in on this charge.
Mr. Stay?
Your Honor, the defendant is pending, I believe, DWLS causing death and operating under the influence causing death in Roscommon County. People would oppose the PR bond.
Did those charges allegedly occur while he was out on bond for this case?
I think so, but I'm not positive. I guess because I don't have that. When this was issued, I don't have that. The court, I do recall looking at something I might be able to access here. The court would indulge me a couple seconds.
you sure you didn't post? I've got that you posted.
I did post a bond. I was bonded out. I revoked my own bond since being here.
That's right. He revoked his bond so he could get credit for time, Judge. So I
Yes.
guess.
And I'm
he's
just asking
you-
the court, since I have 6 months in, to just allow me to have a PR bond so I can bond out of my charges here. And, you know, it's just a lot to try to bond out of 2 counties.
Well,
It was a woman I'm sorry, Your Honor, a woman walking her dog allegedly was killed by the defendant on June 24th of 2023. So this was issued on May 23rd of 2020, or May of 2023. So it would have been subsequent to issuing.
yeah, the court's not going to do a personal recognizance bond on this case. I would set a bond at $25,000 cash or surety. If you want to post that, that's fine, but
My bond was already
$25,000.
$10,000.
That was before you killed somebody while you're out on bond for this case.
Allegedly.
That's all for today.
Robert, I'll be in touch, okay? I'll explain to you what's going on.
That allegedly that he threw in there at the end is what tells me that he has no remorse. None. His only concern is getting out of there to get his pharmacy back. And he's like the bottom of the barrel of the humankind. Seriously. Oh. Yeah. Yes, while he was on bond. So, order of events, right? He gets caught sitting in a parking lot, or gets pulled over in a parking lot. There's something about him being in a parking lot with his lights. Anyways, they find those 3 substances that I mentioned earlier on him. Okay. He gets bond for $10K, pays the bond, and then while he's out on bond, he drives impaired. I don't know whether it was alcohol or substance, but he drives under the influence and gets into an accident, striking a woman walking her dog. And she passes. So that's why he's in the other jail that he's in right now. So he revoked his original bond that he bonded out on, so that he could start earning credit for time served on the case. Because criminals know how to do all this crap. I'd have just been sitting my time out not knowing any of this. So he revoked his bond to get credit for time served. and figured because he's sat 6 months now, and they have agreed in the plea bargain that they're not going to sentence him more than 9 months. He's trying to get the judge to now issue him a PR bond for those remaining 3 months before he times out. And that way he can just pay only the bond of the new case and be free again. Thank God the judge considers him a risk to society. Yeah. Yeah. I'd rather kiss a Picostomus. Yeah. You are not stupid, honey. By no means. Mm-mm. Nope, nope, nope. Oh my gosh. Everybody, with all this, with the weather, the way that it is, the negative temps all over, please y'all stay warm. Yeah, I've heard several of our chat members that are without heat or without water or without, without both sometimes, a lot without power, but you're still watching me. You guys, not soon enough. Yeah, I used to watch a lot of those. I can see their trailer, their opening trailer, but I can't think of the name of it. But it's other countries and how the other countries do it, basically, with bonds and immigration and everything like that. And they, man, other countries, you commit a crime and they don't arrest you until they have everything that they need. And then they go and get you. And they say, hey, we know you did this. We've got all the proof. Come with us. And then you go and you get locked up. Like, none of this innocent until proven guilty kind of stuff, which I love the United States and I love our justice system, but I hate how it's now come to a point where it's being abused and it's all for the benefit of the criminal. I mean, that's how Darrell Brooks happened in the first place. He should not have been released. And during COVID, they released all nonviolent offenders. And then at some point, they kind of just said, well, let's lower the bar on what we consider violent or nonviolent. I don't know what the fix is. Yeah, I wish I knew. Hey, that's a big win. I mean, I'd say at least you don't have to worry about frozen pipes, but that ship sailed. I'm so sorry, honey. I'm so sorry, but I'm glad your sister's not far. I am so sorry, though. I think it was the day before. I can't remember exactly what it was. All I know is he had just been released. And he shouldn't have been. Oh, we all did, especially at the end with the victim impact statements. There wasn't a dry eye in the house. For real. And I loved that one that got snarky with him. That was my spirit animal right there. All right, guys, let's go meet a grumpy judge. He's got sarcasm flowing through his veins, and then it comes out his mouth. We are going to the Commonwealth of Kentucky.
Registration, no rear mirror, trafficking and controlled substance, first degree, second offense.
You're
Possession of
absolutely right.
drug. Mr. Cross, you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, and plea of not guilty, reserving all pretrial motion.
Yes, Your Honor.
Yes, sir, I'm signing a reciprocal discovery order here that requires the Commonwealth to give your attorney certain information to help you prepare for your defense. You need to be here on January 29th at 9 a.m. for negotiations, and February 8th, your next court appearance.
Okay.
There are no complaints that I'm aware of, so you're under the same bond. Okay?
Yes, sir. Thank you.
Okay. Jesse Phillips, active warrant. Mr. Stockton.
Yeah, we'll look in and see how I say, you know.
Terry Phillips Jr. for review. Are you Terry Phillips Jr.?
Yes.
What is this, Mr. Stockton? What kind of review?
This is a review to see if he's paying restitution. He's paying restitution. It's court's order.
Okay. When do you want him to come back?
I don't think I will need him back other than just, it was a problem. And then if it's not paid off, if still the case is not resolved toward the end of the diversion, we'll have to do something.
And if we don't have a grumpy judge at the moment, we've got a grumpy Philip to take his place.
So we continue as generally subject to be redocumented with notice to the attorney.
He still owes about $261,000 on the 2009.
Yeah, so there's 50,000 got paid for
That's going to
that.
have to be credited some way. I've not got anything.
Yeah, I understand.
Okay. So what we need to do on this is you need to keep in contact with your attorney. So Mr. Stockton give notice to the attorney if it gets redocketed, okay? Okay, thank you very much. William Shickles, Commonwealth versus William Shickles, 23 CR 0052. Are you William Shickles?
Yes, sir.
You born in 19?
Yes, sir.
Last 4 digits of your social?
Yes, sir.
Here for a pretrial conference. What do we have?
We'll have a plea, Your Honor.
Mr. Stockton, will you come in?
Pass it a little bit. He's in Edgewater recovery. Won't have a plea if you pass it so we can do the paperwork.
Today?
Yes,
Okay.
yes, Your Honor.
Okay, we'll call you back up here. Alfred Silva.
Judge, he is on his way. He is staying in Somerset, and I had to schedule transportation through RTEC for him to get here. And they had a little mix up this morning, but he's on a bus and he is en route. He will be here in just a few minutes.
Might be like New York City is, we'll find the bus in contempt, sue them. Cody Smith.
Maybe outside, Your Honor, and see the court, because he always attends court.
So if y'all missed that because of his accent, that was the point where I knew I loved this judge. We'll be like New York City and find the bus in contempt. Because the person they want up at the podium is on a bus. I was right there. I was like, oh yeah, I love this judge already.
Commonwealth versus Cody Smith, 23 CR 0067. Are you Cody Smith?
Yes, sir.
You born in 19?
Yes, sir.
Last four digits of your social security number.
No, sir.
What are the last four digits? Mr. Stockton, the wrong social security number
Okay.
is on the indictment.
What is the correct one? And I'll go ahead and say, Mr. Whittenberger furnished me, I'll in order correct.
Okay, I won't say it out loud, but why don't y'all just change it because we were broadcast. Why don't you just change it and then I'll initial it, okay? On each one. See if there's just line through this, put the correct social security number. Initial right there. He doesn't have to initial it, I'll initial it. I'll just line through the rest of them.
See
You
if
have the
he's
right to
lying
remain
to us.
silent. You represented by counsel. You are Cody Smith, as you previously identified. The grand jury of Clinton County has returned an indictment charging you with assault in the 4th degree, wanton endangerment in the 1st degree, terroristic threatening in the 3rd degree, and intimidating a participant in the legal process. You acknowledge the identity of your client counsel, receive the indictment, waive formal reading and arraignment, enter plea to not guilty, reserving all pretrial motions.
I do, Your Honor.
Okay, I'm signing a reciprocal discovery order here. It requires the Commonwealth to give your attorney the information to help you prepare for your defense.
I'll be quiet for a little while and you do actually kind of get used to it and start understanding everything. By the time he gets to the in custody, you'll know it all, what he's saying, and by the time he explains, the day and what it's akin to. Oh, I love this judge.
What's the story on this, Mr. Stockton?
Well, the only issue I'm aware of at this point in time, regardless of bond,
Y'all move to the left here, get behind.
I've been in contact with the victim. The victim, Mr. Smith, have children together. And he's wanting to contact the children, but due to the nature of the charges, he doesn't need to have any contact with her. That's what he was said, that I have an audio recording.
Is there EPO or DVO in
There is, Your Honor.
the district court?
We've got.
Were they ever married to each other?
No, Your Honor. We've got a pending motion in front of Judge Lawson, but the DCI, I think he came in yesterday's office to see about getting restrictions removed as far as for him seeing the kids and I guess get a no contact towards her so they can communicate back and forth about the kids. Your Honor. And then we'll have I guess motion about custody on the kids as far as that goes.
That's the problem. I don't think he should be having contact with other, I think the district court of ever should handle visitation, but I don't think that in this case, I don't want the kids to be a vessel to be used to talk about. That's the problem I've got in this case, because this is pretty graphic.
Well, it's very difficult, when you have these two courts handling something like this. So right now I'm going to be put at the request Commonwealth, have a condition on body, have no contact with the mother of the children. And I think that order will hold. This condition is bond. If he wants to have contact with her, then he'll be in jail and he can try to use the jail phone.
Your Honor, the way they had it
You
worked
understand
out,
what I'm saying?
the way they had it worked out at the district court, my understanding was either your kids called you or you called them directly.
Well,
They had their own phone.
that's neither here nor there. I'll let the district court determine how the contacts with the children, with the caveat that he can't be involved in calling the mother. They can work that out down there.
But if that continues, that wouldn't be a violation of circuit
If he
court.
doesn't talk to her and he's not in contact with her, I don't care what they do in the district court. That's Judge Lawson. I trust his judgment on that thing. You agree with that? I personally, until this is sorted out, wouldn't give him any visitation or contact with the children. If I was doing the EPO or DVO until I had a hearing on it. Have y'all had a hearing on it?
There's already been a DVO established, Your Honor.
Yeah. Okay, that's my ruling. He'll be back here on January the 29th at 9 a.m. for negotiation, and February the 8th for his next court appearance. Both of those are conditions of his bond.
Your Honor, if we have the 8th date changed, I've got a trial in Wayne County starting
That's my
Thursday.
rule date. I can't change my rule date.
Okay. I'll see about having somebody come down and cover. it.
Yeah, well, if you negotiate a plea or something, they can enter it that day. If not, you can bring somebody with your calendar down.
I'll do that.
Okay.
Thank you, Your Honor. I have nothing further in front of the court. May be excused.
Absolutely. Thank you.
Yeah, don't you know that's his rule date? And old men do not change their routines.
John Tucker. Commonwealth versus John Tucker, 23 CR 0054. Are you John Tucker?
Yes, sir.
Born in 19.
Yes, sir.
Last 4 digits of social security number.
Yes, sir.
You're here today for the purpose of arraignment. You're represented by counsel. Mr. Cross, you have a right to remain silent. If you have any questions about the proceedings, step away from the microphone and privately communicate with Mr. Cross, okay? The grand jury of Clinton County returned an indictment charging you with unlawful use of electronic means originating or received within the Commonwealth to induce a mind to engage in sexual or other prohibited activities. Prohibition of multiple convictions arising from a single course of conduct. Solicitation as evidence of intent. You understand those charges?
Yes, sir.
Yes, Mr. Cross, you acknowledge the identity of your client received indictment was formal reading or pleading not guilty, reserving all pre-trial motions.
Yes, Your Honor.
You sign a reciprocal discovery order that requires the Commonwealth to provide your attorney with the evidence that they have concerning your case. You need to be here on January 29th at 9 a.m. for negotiations, and your next court date's on February.
Your Honor, I
The eighth.
would anticipate that this prep on this will take a little bit longer due to electronic review necessary and such. I don't think it's going to be very productive to have it on the 29th of the 8th.
What do you have to say, Mr. Stock? Come around here.
The discovery is not that extensive. It's Mr. Cross is gonna hire an expert or something. It's not that extensive or something.
See, I don't know. We've not
Yeah.
looked at that.
Well, y'all just be there on that date, and if that's the case, you can give your reasons why you don't want to negotiate. And, and your rationale as to how long you think it'll take to do that. I just like to keep it on schedule.
Fine, Your Honor.
Okay. Commonwealth versus Candace Tweedy, 23 CR 0058. Ms. Tweedy, were you born in 19?
Yeah.
Last 4 digits of social security number. Okay. The grand jury of Clinton County has returned an indictment against you. You're represented by counsel here. I want, if you have any questions about anything I say, step away from the podium and speak quietly to the attorney. The grand jury charged you with possession of marijuana, possession of controlled substance, the first degree, possession of controlled substance, the first degree, no charge, and possession of great paraphernalia. You understand those charges?
Yeah.
Also, do you acknowledge the event of your client receiving indictment, waive formal reading arraignment, interpleading not guilty, reserving all pretrial motions?
Yes, Your Honor.
Signing a reciprocal discovery order. You're to be here, ma'am, the next time on January 29th, 9 a.m. for negotiation, and next court dates February the 8th at 9 a.m. and both of those are conditions of your bond.
She have any restrictions on her bond, regards to curfew?
Yes.
I've been getting complaints from city police about her going out midnight, it's various individuals and things. And I just want
Okay.
to stop that.
Don't respond to that. Okay. I'm telling you, work, church, or the doctor. That's where you stay at home. And as they used to say in Monroe County, you don't need to be out of gomming around.
Ooh.
Yes, sir.
Okay, thank you.
Yes, Your Honor.
What is a gammon around? Anybody else know that? I'm not familiar with that phrasing. A gammon around. Busted. Hey, you. Welcome to the party. I hope you're staying warm. Good to see you, though. And Becky D. Oh no, Emily. Rather than us moving to find us a nice Southern boy, how about we go find a nice Southern boy and move him to us? I don't know if he could handle the cold.
Alfred Silver, Commonwealth versus Alfred Silver. 3CR 0048. You're Alfred Silva.
Yes, sir.
Born in that.
Yes, sir.
Last 4 digits, social security number to give you with you today.
He's here for his duty to register. We missed that last court date. He needs to read it to him and he needs to sign all 4 copies and open the court.
Clinton County.
Why don't you take those in the back room? And you want to be there with him and go over it quickly, or?
Yes, Your Honor.
Okay, is there anybody else here on the live docket that was out? I guess we didn't do anything about Ashley McCusker, right?
Yeah, we're going to do the plea paper here.
Dylan Murphy. What about Dylan Murphy? Processing. William Schiffels. Working on paperwork for him. Alfred Silver just went back. Kyle Thomas is in the Clinton. Okay, well, let's go off the record just for a second. Okay, we're back on the record. Mr. Silva, did you look at those duty to register forms? Are they all in order? Did you,
Yes,
you'll
sir.
sign them now here in open court?
Yes, sir.
Probation, any other need to talk to Mr. Silva today?
So sometimes when the judge is talking, you can't really see his mouth moving because that's just, I don't know, crabby old man thing. I can't tell you how many times I've seen that. But anyways, so when the docket first started and I'm hearing this voice, I'm like, I'm thinking somebody else is talking, that it couldn't be this judge. And I was like really having to focus on his mouth movements and make sure that there were any. And sure enough, yeah, that voice is coming from that man. I couldn't believe it. Ooh, I miss snuggling. It's been a lot of years since I've had a snuggler. A lot of years. I haven't even had a hugger for a long time. I'm talking, more than a decade. Yeah.
I will after you sign them. Thank you on that. I will.
Well, in a continuation of a very unusual day, my pen is on that. I'm going to get an official pen. I can't be using your pen. Yeah. That's the worst thing that happens to me all day. It's already not the worst thing to say.
And Your Honor, if I may, you had indicated to Mr. Silva, whenever we were here for final sentencing, if he could show proof of being admitted to long-term rehabilitation, that you would waive full costs. He is currently enrolled in long-term rehabilitation.
I don't remember that. Submit me an order.
Yes, Judge.
Okay, I don't guess we have anyone else here right now.
Thank you, Judge.
Yeah.
Thank you, Your Honor.
Yeah.
Mr. Sylvia, just wait right there and I'll be out.
Commonwealth versus Dylan Murphy. 23 CR 0057. Are you Dylan Murphy?
Yes, sir.
Born in 19.
Yes.
Last 4 digits social security number. Yeah. You're here today for the purpose of arraignment. You have the right to remain silent. If you have any questions, step away from the podium and ask your attorney quietly. The grand jury of Clinton County has returned an indictment charging you with wanton endangerment in the first degree, 2 counts, and criminal abuse in the second degree, 2 counts. You understand those charges? You have to
Yes,
say
sir.
so audibly. You understand those charges? Counselor, do you acknowledge the identity of your client received indictment, way formal reading arraignment, and you're pleading not guilty, reserving all pretrial motions?
Yes, Your Honor, and just for the record, I will note, and I've already contacted DPA office above my head. Mr. Murphy is a co-defendant with Ms. Farrell. I have already had extensive conversations with Ms. Farrell, so. No,
You
Mr.
handle
Murphy.
the arraignment though.
Absolutely, Judge. I just want,
What you're telling me is that you're gonna have to get conflict counsel.
yes, Your Honor.
Okay, we'll have conflict counsel here on January 29th and at 9 a.m. and this gentleman will be there on the same date, and then on February 8th is court appearance,
Yes, Your Honor.
okay?
January 28th is 29th.
January 29th. 29th.
You know, nowadays, Judge, they just say less. But the judge has his own way of telling him to say less.
Change that, and then February the 8th. Both of them at 9 a.m., both of them motions about it. Who else?
Who's next, okay? Earl.
Commonwealth versus Ricky Farrell, 23 CR 0056. Ricky Farrell.
Yes, sir.
You born in 2000.
Yes.
Last 4 digits social security number.
Yes, sir.
You're here today for the purpose of arraignment. You have a right to remain silent. You're represented by an attorney. If you have anything, don't understand something, step away from the podium.
Okay.
And ask him quietly. The grand jury of Clinton County is returning an indictment charging you wanton endangerment, first degree, 2 counts, and criminal abuse in second degree, 2 counts. You understand those charges? Okay. You have to speak up.
Yes, sir.
Okay. Counselor, you acknowledge the identity of your client received indictment. Wait for reading and arraignment, interplea not guilty, and reserving all pretrial motions.
Yes, Your Honor.
You'll be back here on January 29th at 9 a.m. for negotiations, February the 8th for your next court appearance. I'm signing a reciprocal discovery order. It requires the Commonwealth to give the evidence they have in the case to your attorney, so to help you prepare for the case. Both of these things are conditioned to your bond, okay?
Yes, Your
Thank
Honor.
What is her bond?
10,000 cash.
Okay,
It was 50,000 district court, she was on some cash first.
okay. 10,000 cash is sufficient,
Thank you.
and with the same conditions, okay? Okay, we have anybody else ready here? Who is this gentleman?
What's your name, sir?
Kyle Thomas.
Kyle Thomas.
Kyle Thomas, yes, Your Honor.
Commonwealth Kentucky versus Kyle Thomas, 23 CR 0051. Mr. Thomas, were you born in 19?
Yes, sir.
Last 4 digits, social security.
Yes, Your Honor.
The DPA represents you in district court. He's what?
I had an arraignment, they had an arraignment for me, but I was in Wisconsin. I wasn't here for it, Your Honor. I knew nothing about it.
Is there a warrant out for him? Was he in judge?
Yeah, in December, that he had his service to the service for the title to December 11th.
Good.
And also so you can say his name, maybe not ready to back. He's given the wrong stuff at back. You know, how
It's Alan Kyle Thomas. I just go by Kyle because my dad's name.
For arraignment.
That was the
Yeah, it's listed as pretty.
pre-trial.
Okay. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with wanton endangerment, first degree. You understand those charges? Now, I'm not asking you what you did or not. You understand what the charge is?
Yes, Your Honor.
Okay, I'm signing a reciprocal discovery order in this case. The Commonwealth give you the evidence they have. What's the bond in this case?
I don't have your twins involved here. I think it's for direct indictment. I don't think it was a district court back.
Mr. Stockton, have you looked at the allegations on facial involves use of a weapon and shooting in the direction of somebody, 5,000 sufficient.
Yeah, I think in this case it probably is because he was in an altercation with Joe Daly, who's a fugitive from justice, and I don't know if he's ever been picked up or not. And the reason I was alerted to this was my neighbor called me because he observed the altercation, which is I guess, 1,500 feet of my house. And they were fighting in the road, and then Sheriff Markham got to investigating it, and then he brought them down.
Okay.
You know, it's probably a bad day for you in court when your altercation happened 1,500 feet from the prosecutor's house. You don't want that.
I'll let the bond what it is. You're not to have any firearms about you though. You understand that? You understand that? You're not to have any firearms on you. You understand that?
Yes,
Not in the vehicle you're in, not in the house you're in, not anywhere. You understand that?
yes, sir.
Okay. Okay, you be back here on January the 29th at 9 a.m. for negotiation. And February the 8th is your next court date. Now, you said you were where previously? You're at Wisconsin or
So
something?
that's where I was working.
What kind of work do you do?
I do roofing, industrial buildings.
Yeah.
We sent him back.
You got out-of-state jobs coming up?
I do, but
Well, here's what Mr. Stockton,
Yes.
if he's working out of state as a roofer or something like that, you won't have any objection if he gives notice to pretrial where he's gonna be located doing the roofing for him to continue to work. will you?
No, I'll have no objection.
You understand what I'm saying? But you need to be specific in calling and have your attorney tell the Commonwealth Attorney's Office.
If he can make the ball,
If he can make the bond.
and
What is the bond?
5,000 cash, he got the ball, he has my history.
Yeah.
I can't make the bond here.
Judge, could I ask for a surety or electronic monitoring in lieu of a cash bond so he can get back to working?
I mean, some of my family do, but I don't know if they're willing to. Okay. I speak.
You just step away and talk to your attorney. Today's been kind of like one paint dry.
And Judge, I think it's important to know Mr. Thomas is claiming self-defense in this.
Well, I understand that, or we wouldn't be talking. Mr. Stockton alluded to that. You know. But let me tell you what, when you've got nobody at all in your family or anybody else that'll sign even, I'll change it to $10,000 surety bond for somebody in your family come in and just sign a surety bond.
Thank you, Judge.
Thank you. Who else do we have here on this out of custody docket? Yeah, have you got paperwork being done on someone? Mr. Pennington, do you have paperwork you're doing on anybody?
Judge, I think for waiting for Mr. Secretary right now, he's completing his PSI paperwork, so not.
If you got the paperwork, you can go ahead and do it.
Well, I don't think that complete paperwork, he's doing the PSI.
Yeah.
That's my favorite song, The Wellerman.
Adair County? Adair County, if you'll join us, I see you're online. Turn your camera on. You need to turn your microphone on in Adair County. You are muted. There you are, Adair County. A case of Dennis Kempton, Commonwealth Kentucky versus Dennis Kempton. Okay, you're off again, Adair County. Okay, there you are, Adair County. Unmute your microphone. There ought to be a place on the screen there that's got a little microphone with a X across it. There you go. Can you hear me now? Hello? Hello?
Oh, we better use it. That's it.
Well, Kentucky versus Dennis.
Boy, the volume won't come up. I can't get the volume.
Are you Dennis Kempton?
I think that's the staff. That's a Class D facility, like, they don't do as much Zoom as the.
Most of them aren't from here. I've been there for several Christmases. Okay, moving right along here. The local basketball game doesn't start till 6. It appears we might be finished by then.
Don't get your hopes up,
In Harris
Judge.
County, if you have an 18-year-old house up there, they might be, usually younger people can get online better. Yeah. I remember when we first started using, here we are.
I don't know if y'all can hear me, but I can't get no sound.
Well, it's either Adair County or the aliens have come to abduct y'all.
Can you hear me now? Are the headphones plugged in? Maybe take the headphones out and the speaker will work.
Okay, I got it. I'm sorry about that, Mr. Williams, but we got volume now.
Can you hear me now?
Yes, sir.
Okay, you have Dennis Kempton there.
Yes, sir.
Okay. Commonwealth versus Dennis Kempton. Are you Dennis Kempton?
Yes, Your Honor.
You were born in 19.
Yes, Your Honor.
Last 4 digits of social security number.
Yes, Your Honor.
Your attorney is here, President Wade, counselor. Hello. Okay, you're going to be arraigned here on a charge. You have a right to remain silent. If you have any questions about what's happened here today, he'll be back in contact with you, okay?
Okay.
The grand jury of Clinton County has returned an indictment, Mr. Kempton, charging you with burglary in the 3rd degree, criminal trespass in the 3rd degree, and theft by lawful taking or disposition. I'm presenting this indictment to your attorney, counselor.
Not tonight,
You
Brian.
acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty.
Yes, Your Honor.
I'm signing a reciprocal discovery order here. Your attorney will be receiving certain information from the Commonwealth to help you prepare for your defense. He'll be up to see you right soon. You're going to be back here in court on January the 29th. And for back here at the courthouse in Clinton County on January 29th for negotiations, and on February the 8th for your next court appearance. Now, is this gentleman being held on other charges?
He's a state inmate.
It's a state inmate, so he'll be up there to see you, okay?
Okay, thank you, Your Honor.
There's nothing else there at the detention center, so Adair County, y'all are excused. Thank you for your help.
Thank you, y'all.
Is Kenton County on there yet?
Got court.
Kenton County. What, Wayne County? Wayne County, okay. Commonwealth versus Jesse Pittman. Hello? No, somebody needs to activate the microphone in Wayne County.
Hello?
Okay, that's got it there.
All right, thank you.
Commonwealth versus Jesse Pittman, 18 CR 0074. Are you Jesse Pittman?
Yes, sir.
On the 19th,
Yes, sir.
last four digits of social security number.
Yes, sir.
You're here today on what says to be a motion to vacate. Mr. Stockton, what do you have?
This is the case we heard last month where he was asking to vacate the 18 case because that's what he's serving his parole on. He was revoked on a domestic violence case, which I ended up dismissing, but the parole board had already given him a year to serve, I believe. Is that right?
I think it was yeah.
Yes.
And he's asking to go back and vacate the 18 case where he was involved in self-defense.
And Judge, oh,
DPA post convictions involved.
that's what I was about to say.
Is it Andrea Reed?
Yes, Your Honor. Samantha Costello reached out to me earlier this week and asked if post-conviction could take a look at the motions that Mr. Pittman has filed. We only have the one that was filed on November 8th of last year,
You need to
so.
move closer to the microphone and speak up a little bit. My sound system here is not great.
Okay, I'm not sure what you caught of that, but Ms. Costello reached out to me earlier this week to ask post-conviction to take a look at what Mr. Pittman had filed because it's a post-conviction action. And we only have the copy of the motion that he filed on November 8th of last year. We don't have anything else that he has filed yet. We know that you appointed somebody, I think at the local office, but there hasn't been an appointment order for post-conviction to enter an appearance and look over this case. We are happy to do so if you would like to enter an appointment order so we can review his post-conviction motions and see if there's anything we can do to help him out.
Can you send me an order down? Andrea,
I'm sorry, Your Honor, I couldn't hear you.
Is there a AOC order form? Where will I get the order?
Would you like me to send you a proposed order, a tendered order?
Send me a proposed order, I'll sign it right away and we'll
Okay.
get you to work on the thing.
Yes, I can do
Cheryl,
that.
can you help her get the order together?
Yes, Your Honor, and I will make sure that she has all the contact information.
Okay, now we're next here on February the 8th, but since everything's gonna be done remotely here, I will consider you picking one of the other two venues that we have over in Burkesville or Tompkinsville to get him back in front of us when they're ready to get back in front of us, okay?
Thank you, Your Honor.
Okay, thank you very much. Mr. Pittman, things are in operation now, okay?
Okay, thank you, sir. I sent in another motion myself. I sent in one for grounds on the 1142.
Well, you need
And,
your attorneys.
Okay, I sent it to the
You're
clerk's office.
you're not on the docket for that today, but
Okay.
we're aware of that. We'll take a look and see if we can find it, okay?
All right, thank you, sir. So she'll be in touch with me?
Janet Owenby there, is she there?
Thank you.
Thank you.
Yeah.
Commonwealth versus Janet Owenby, 23 CR 0035. Are you Janet Owenby?
Yes, sir.
Born in 19.
Yes, Your Honor.
Four digits of social security number. There is an issue here about a competency hearing. What does the Commonwealth know about that?
Your Honor, I can clarify. I tendered the order this morning.
Okay.
Thanks for that.
You just want me to sign an order scheduling a competency
No,
hearing?
she's already been evaluated and we didn't know if he was going to stipulate or if we had to have a hearing.
That is correct.
Well, somebody needs to tell me about it, you know.
Yes, Judge, we went over the paperwork. It's on me.
Okay, are you stipulating?
Yes, Judge,
That's
yes.
all I need to know.
Well, you
Okay.
wanted her signature on the agreed order, so you.
Is she there? She signed it?
Yes, Judge.
Let me see it here. Miss Owenby, I'm showing you that. Can you see that there? Is that your signature on there, Miss Owenby?
Yes, yes, Your Honor.
Okay, well, I'll sign this and we'll get things underway for you, okay?
And Judge, if we could get
February the 8th for pre-trial.
and if we could also get that 29th date, Judge, I'm hopeful,
January 29th for negotiation.
and I'm hopeful to have placement for her by then. Thank you, Your Honor.
Okay, that concludes. I guess we don't have anybody else over at Wayne County. So thank you all as always for your cooperation. Wayne County can be excused. Where's Jamie Ortiz there? What is that? What's Western? Let's go to Western Kentucky Correctional Complex.
Tell them your name.
Bobby Phillips.
Okay, Commonwealth versus Bobby Phillips. Are you Bobby Phillips?
Yes, Your Honor.
Were you born in 19?
Do what, Your Honor?
Were you born in 19?
Yes, Your Honor.
Last four digits of social security number.
Yes, Your Honor.
Here for a pretrial conference. Where did Mr. Pennington go? Mr. Pennington. We're hunting your lawyer down here, Mr. Phillips. We have Mr. Bobby Phillips on the line here with a pretrial conference. What do we have?
Well, we've entered an offer, Your Honor, and I think it was what the defendant wanted, so we just need to get another date so we can enter the paperwork.
What's the deal on this paperwork?
This was the one that I had to go meet the victim who's in the hospital, so they.
We don't have paperwork on anything today. Is there something we can do to help you with this stuff, or the Commonwealth needs to be done differently?
Well, Judge, I think one of the Commonwealth's assistants was out, so there wasn't a printer to print paperwork last Friday.
That's correct.
You want to set a different date for Mr. Phillips?
Judge, I'm certain, and I checked with the Commonwealth. I was gonna have him transported today. He hadn't had a chance to speak with the victim yet, so. Yeah, the deal's what we wanted.
Is he a state prisoner?
He is, Judge.
So it won't affect his incarceration, so we can schedule it then for February the 8th. Is that correct?
That's correct, Judge, and I'll tender a transport order today.
Well, he doesn't have to be transported. If he's already gonna be a state prisoner, you're gonna run it at the time. He doesn't have to be, you want him transported. Or you need to go see him probably. I mean,
Yeah, absolutely.
you need to go see him, and then
The only assistant in the county who knew how to print something had the day off. And no one else knew how to operate a printer.
you can decide whether you want him transported.
Yes, Your Honor.
I'll have him, if he does, it's your responsibility. Mr. Phillips, they say they got the paperwork done on you. They're gonna bring the paperwork down and go over with you so you can see how it affects the service of your time you're already doing and this new plea agreement. Your attorney needs to come down there and meet with you face to face. So, okay, you see what I'm saying? So you can be fully informed about what you're getting into. Then we'll decide, if you reach an agreement and sign the documents, we'll decide then whether you need to be brought back up here or whether we can just do it by Zoom on February the 8th, okay?
Thank you, Your Honor.
Thank you, and Western Kentucky Correctional Complex, thank you for your cooperation. Y'all can be excused.
Thank you.
Okay, Russell County Detention Center. Y'all will turn your camera on.
I love how, though, okay, so the judge first kind of admonishes them for it a little bit. We have not got paperwork on anything. But then he's like, is there something we can do to help you? Like, that probably made every lawyer in the room feel like this big. Like, seriously, if you're a grown ass adult doing your job and somebody says, is there something we can do to help you? It's really putting into perspective that you're not doing your job to their satisfaction. Like, that is the worst statement that the judge could have made for those lawyers' egos.
Russell County Detention Center. Russell County.
Hang on just a second, Your Honor.
Okay, thank you.
Okay, is it on now, Your Honor?
There you go. Commonwealth of Kentucky versus Stephen Bridgman.
Yes, Your Honor.
Commonwealth of Kentucky versus Stephen Bridgman, 23 CR 001. Are you Stephen Bridgman?
Yes, Your Honor.
Born in 19.
Yes.
Last 4 digits social security.
Yes, it is.
Okay. This says there's some motion for shock probation.
And this one isn't good because the judge remembers this guy. And that doesn't go over well.
Also final sentencing, I believe, Your Honor. I've got the one case and Mr. Mr. has the other.
It's not on for sentencing.
He's already a state inmate, so I believe he can waive the decide. This is a case, Your Honor, where we had filed for motion for shock back in November. You had referred him for an assessment for drug court. They did the assessment. I was not present in December, and so it was continued to today. So we're asking that he be released to go to drug court.
Mr. Stockton?
Yes. The way I look at this case, Your Honor, is Mr. Nally served about 4 or 5 months in jail and cooperated. Mr. Bridgman didn't cooperate, took the case to trial. He wasn't found guilty on the arson, but he was found guilty on the tamper, and he got a 5-year sentence. He's going to be parole eligible here probably about June because of the 5-year sentence. I know he used to do pretty well in life till he got on drugs. Drug court would be appropriate. I think the Commonwealth wouldn't have an objection to drug court because we'd have more control over it, to be honest with you. Yeah.
Yeah, I was gonna say that because the judgment order and all that on the other case has been done signed, and if that close the case, it didn't vote that. Yeah. So you want to do the silence on this.
If he hadn't been found guilty, of arson, he wouldn't be having this.
And this is also the defendant, Your Honor, that his wife passed away between the trial and the sentencing. Leaving his son at home with no income.
What's it?
Your Honor, may I speak as well on behalf of Mr. Bridgman?
Yeah, we have any other attorneys here that might want to chime in that
Well,
aren't, that aren't for record? Here, just line up behind Mr. Cross there.
If he's going into direct court, he's getting out on our case, of course. I want to say this about Mr. Bridgman. He's one of the first clients I ever had when I started practicing law many years ago in a workers' comp case. He has at times done very well in life. He has the potential to be a good citizen. I think that knowing Steve as well as I do, I think that he benefits much more from the supervision requirements of drug court than he does by simply being paroled. I think that works in his best interest and the system's best interest.
I was really shocked he wasn't convicted of arson. Somebody burned that cabin down, and there was testimony about it that directly placed him there, and there were all sorts of circumstances, but he wasn't convicted of arson. But that building was burned down. It was a total loss for the owner of the building. I just can't get that out of my mind. I can consider all the facts I know about the case, even that.
The other defendant pled guilty to it, Your Honor. Nally pled guilty to it.
I understand that.
Okay.
And you remember what he testified to also, don't you?
Right.
Yeah.
Right. But that was the only evidence that Bridgman was involved, was his testimony.
And he was found not guilty.
Yes, sir.
What was he found guilty of?
Tampering with evidence, Your Honor, the liquor bottle.
I remember. I remember what he was found guilty of. What's Commonwealth's position on this?
Well,
Is there a victim here that needs to be notified?
well, Mr. Heist is lost financially. he came and he testified. I've not heard from him since. I could contact him if you want me to. Financially, you know, for some people, that'd be a great loss. For him, financially, it's probably not. So I don't know what his feelings are. I need to talk.
That's what, with his testimony at the trial, that the people who consider the destroying his property very important.
Because
he was wealthy.
That was the testimony.
So I just don't want to open up, let people be making decisions on things like that. I will take it under advisement. I do think that there is a valid argument that most people would do better under the supervision of the drug court if they've got a drug problem. I don't remember that, I don't have any information in front of me that he has a drug problem. You know, it wasn't brought up at the trial.
As my role as Commonwealth attorney, I hear things and know a lot of things that I can't prosecute. And that Mr. Bridgman can dispute it, but I know he's had a drug problem for quite some time, either through his family members or through the.
Mr. Bridgman, do you
Yes,
think
Your
that
Honor.
you would benefit from participating in drug court?
I didn't hear you.
I said, you have a drug problem. Have you had a drug problem, Mr. Bridgman?
Yes,
Okay, and do you believe that you would participate, that participation in drug court would be a good alternative to you to try to address that problem?
yes, Your Honor, I believe it would.
Okay. Okay, I'm gonna grant the motion.
Thank you, Your Honor.
I'm gonna grant him shock probation. And pursue
5 years from today.
5 years from today. He'll be on probation for 5 years and they'll be over, I guess, him and interviewed and that sort of thing. When I'll let him
No,
know.
he hadn't been assessed, been assessed.
Okay. Okay, well, they'll vote on you getting in drug court as soon as they do. If when they open up for the orientation, I'll let you out if they vote you in, okay?
Okay, Your Honor.
Okay, thank you.
Thank you, Your Honor. That's all that I have. Could be excused.
Sure.
Thanks, sir.
Darian Riddle.
Yes, Your Honor.
Commonwealth versus Darian Riddle. Mr. Riddle, you born in 19,
Yes, sir.
last 4 digits, social security number.
Yes, sir.
You're here today for arraignment in 23 CR 0062 and 23 CR 0068. Now, were you previously represented in district court by DPA? I'll continue that. Cases. You have the right to remain silent. If you have any questions about this arraignment, your attorney will be there to consult with you. The grand jury of Clinton County has returned an indictment charging you with receiving stolen property and being a persistent felony offender on receiving stolen property.
Now, I don't know how old that one woman was, but I do know this man is the same age as me.
And also theft by unlawful taking or disposition and being a persistent felony offender on that. You understand those charges. I'm not asking you whether to discuss it or whether you did it or not. Understand the charges?
Yes, sir.
Okay. Counselor, you acknowledge the identity of your client received indictment, waive formal arraignment, enter plea of not guilty.
Yes, Your Honor, to both charges. Or both cases.
Yeah, waive formal arraignment and reading of the indictment. Okay, I'm signing reciprocal discovery orders. Now, Mr. Stockton,
Yes.
are these two cases, I noticed that are they separate occasions and separate things that were
That's my
stolen?
understanding, yes. One's involving, they're two different victims.
Okay. Okay. We have a negotiation day set for January the 29th at 9 a.m. You're responsible for the transport order. And then the next is February 8th, court appearance, okay?
I'll be over to see you, Darren.
All right, appreciate it, Miss Brenda.
Chris Thrasher.
Your Honor, give me
Commonwealth
one
versus
moment.
Chris Thrasher.
Your Honor, give me one moment. I'll get Mr. Thrasher out due to the nature of his charges. I can't have him with these.
Okay, thank you. Mr. Leverage, I didn't know you were here. Beautiful day out there. It's a nice drive over. What is it? Is the lake really low?
It's still really low. Yeah, I get distracted before they're getting ready to put the bridge piles.
Can you see it downriver pretty well?
Once you get down, you can.
From the dam, can you see it?
Between,
It's farther on downriver than that.
it's impressive, some of the.
I spent 25 years ago, I started. Can't tell you the number of hours. You know, you got delayed and canceled and moved around. Be hard to stop it now, won't it? There's still a section between, there, excuse me, skip back. Commonwealth versus Chris Thrasher, 20 CR 0087. You're Chris Thrasher?
Yes.
You born in 19?
Yes.
Okay, here's for a pretrial conference. Is all the discovery and everything finished in this case, or?
Yes.
Okay, are you ready for the trial?
I think we need to trial the judge.
Okay,
And if possible, a pre-trial also.
okay, we'll do you. Pretrials are a lot easier to set.
Mr. Thrasher, who they couldn't bring out with the other inmates due to the nature of his charges. I don't know yet what his charges are. I can't remember, but like, wow. Like, I've never heard them have to separate the inmates like that for the hearings. To not even be able to bring one of them out with other inmates. Crazy.
We had talked a little bit before court, Mr. Leverage tells me he's got a motion to file. And I told him I intend to file a motion for change of venue, so.
You agree with that, won't you?
Change of venue?
Yeah.
I, not right off, Judge. I like to change.
Yeah, well, you know, we've already tried one case here in this situation that's related to this situation. We didn't have any trouble seating a jury, really. And I don't, of course, it was a pretty harsh outcome of the trial, but that doesn't necessarily mean that it reflects upon where the jury, you'll need to substantiate it pretty well.
Times two,
Unless you're
love.
in agreement on that. When do you want to file these motions? Let's set February the 8th as the date that you, either one of you have any motions. Mr. Lever, do you have anything you need to file, or?
There will be a motion I'm planning to file.
Okay, and maybe both of you serve each other in time for you to have responses for that and be back here on February the 8th. And on that day, if we haven't reached a resolution for the case. Now, if you need any testimony on that date as far as change of venue, you need to give Mr. Leverage some notice on that, so he'll be able to accommodate it after the end of the docket somewhere. You know, it might be during the lunch hour or something like that, so we can get both of you away from here during the lunch hour at least. From what's happened today, we might have a heavy docket next month because we put a lot of things over. Okay?
You want to give that still be judge?
Well, it just depends on whether you're gonna take testimony. If you're gonna take testimony, we'll set a time certain so you won't have to come around, or we could come in earlier than that. Both of you operate on fast time, don't you? Yes, sir. And you get up early, I'm sure. So it might be better for both of you if we try to accommodate you at 8:30 or something in the morning. So we can hear the testimony, hear your motions, and get y'all on the way. That way you won't have to sit here and suffer through the rest of these things. Okay? So we'll just be waiting to hear from both of you, okay?
All right.
Did you catch all that, Mr. Thrasher?
Yes, I did.
Okay, thank you very much. Now, we don't have anything else in Russell County right now, so Russell County, you may be excused.
Judge Gunner's.
All right, thank you, y'all.
Y'all have a nice day. Enjoy the drive back.
And mind the river.
Clean that area over there. We never did get Kenton County. Or Kenton County, there you are, okay. Kenton County Detention Center, Commonwealth versus Cody Chilton. 17 CR 00055. Are you Cody Chilton? Okay, they'll have to unmute the microphone there. The microphone is muted, please. Commonwealth versus Cody Chilton.
Is it
Mr.
unmuted
Chilton.
now?
Okay, yes, you can. Mr. Chilton, were you born in 1980?
Yes, sir.
Last four digits of your social security number.
Yes, sir.
You're here today on something to do with a shock probation revocation. Mr. Stockton, you want to come around?
I didn't know.
Okay,
Your Honor, before we get started, let me say, I represent Cody. I didn't know he'd been picked up. I didn't have this on the docket. I really know about it, little about this as anything other than he's got some issues.
Mr. Stockton, tell me what this is about.
Yes, probably with it.
It probably went to James.
Well, no,
Yeah,
it says it went to both.
Yeah, went to both of them.
Okay, that's.
Tell me what's going on, Mr. Stockton.
Mr. Chilton has a 10-year sentence on burglary and fleeing and evading possession of controlled substance. He's the one that had a DUI charge in Hardin County that's laid up there for a year and a half. I don't know that they ever disposed of it, so we kind of sanctioned him a while and he kind of floated back and forth. But during the pendency of waiting on that DUI conviction, besides these other problems, he's got a new arrest in Kenton County, domestic violence, assault, and he had 2 handguns with him on his backpack, a Glock.
And you want to do a shock probation with him, which, what that is it's a program where felons can be, their term is significantly reduced, somewhere between 30 and 180 days, and then they're released back into the public with a probation sentence. Like, that, I'm sorry, to me, how is that any different than making it basically a misdemeanor? I mean, all you're doing is taking away their right to have pew-pews and vote, but I mean, seriously, how many people does the court orders actually matter to if that's the type of person they are?
9mm and a 40 caliber Smith and Wesson, I'm asking it to be revoked. If I have to get the officers on Zoom from whatever, from Kenton County, I'll do it, but that's my position.
Mr. Cross, you represent Mr. Chilton.
I do, Your Honor. And Cody, you heard what he had to say.
Here, yes, sir. May I say something? May I say something?
Probably better not.
Why don't, what county are you in now? You in Kenton County?
Kenton County.
Yes, sir.
Yeah, okay. I'd better talk with Your Honor.
I'd say that would probably be good.
Yeah.
I will reschedule this on February the 8th, Mr. Chilton, to allow your attorney to talk to you privately. You have a right, you have a right to remain silent, and if you say anything there, it can be used against you. And also, this will give us opportunity to bring the officers that made the new arrest.
They appear by Zoom.
I will allow them to appear by Zoom. And Mr. Cross, if you want Mr. Chilton transported for this thing, you can get a transportation order. Otherwise, he will appear by Zoom.
We'll make that determination, Your Honor.
We'll
Thank
do
you.
it.
Cody, I'll be in touch.
Do it.
All right, thank you.
Don't get it the day before, okay? Thank you. Thank you, Kenton County, for your cooperation.
Thank you for your patience, sir.
Thank you.
Yeah, Becky D, who knew? What a shock. That's the shock probation.
Okay, let's go to the Clinton County Jail, I guess. We have anybody else here in the courtroom?
Judge, we have two pleas.
Oh, yeah, we need to clear that area out over there, bring the grand jury in.
Felons
Bring the grand jury
included?
in. All rise for the grand jury, please.
They don't even turn the cameras up as the jury walks through.
Okay, everyone can be seated. Who's the foreperson of the grand jury? Madam foreperson, have y'all completed your work? Have 9 or more of you agreed and authorized you to proceed with your signature on there?
Yes, sir.
Have you present that to the bailiff? You may be seated. Let me examine the document. Okay, ladies and gentlemen, the grand jury, I've looked at the documents that were presented to me. They appear to be in good order. I'm going ahead and sign an order, and we'll determine as we look at these whether we'll have criminal summons issued for individuals or whether we will have warrants. Usually if they're not in custody, we do warrants with bond on them. It's our responsibility to set the bond and amount to assure that they will appear. And if they're dangerous, to make sure that there will be limitations to protect individuals that might be victims. Therefore, it's very important that you keep confidential any information that you received in the grand jury about this or any other matters for the protection of those who testify. Hasn't happened here in Clinton or Cumberland County, but in some counties around, we've actually had people injured and some deaths where stuff leaked out of the grand jury did. And sometimes people decide to get scarce if they've been indicted, if you follow what I'm saying. So thank you very much. Unless you're called back in case of a special grand jury for an emergency or insurrection of some sort, you'll next be back here on February the 8th. In the world we live in, who can tell whether there's an insurrection coming, right? We just don't know. But if you see a CNN and Fox going around the Clinton County Courthouse, you'll know there's been an insurrection. So thank you for your work, and you can be excused. All rise for the grand jury. Thank you all very much. Okay, let's go back to you have a couple of pleas, did you say?
Yes, Your Honor. Let's start with Ashley McCusker.
And who is this you have with you?
Ashley McCusker, 23 CR 49.
I got it here. Commonwealth versus Ashley McClusker, 23 CR 0049. Miss McClusker, you were born in 19.
Yes.
And it's last 4 digits social security number. What do we have here? A felony plea or
No, it's a misdemeanor.
misdemeanor plea? A motion, you can get behind the microphone. A motion been tendered says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes.
You've previously been identified as the same person named in this indictment. Is that correct?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed the charges with your attorney?
Yes.
Are you satisfied with his advice?
Yes.
Have you reviewed all the evidence Commonwealth has against you?
Yes.
You believe you're fully informed about the case?
Yes.
Understand that you do not have to enter a guilty plea today. You understand that? You have certain rights under the Kentucky United States Constitution. I need to know that you fully understand those rights. I'll ask you at the end if you wish to. Okay?
Yes.
This is a misdemeanor, so I won't have to have a pre-sentence investigation. So I'll make my decision today. I accept it based on information I have. In the event that I don't accept the recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Y'all will move to your left. Mr. Stockton, come forward and give them what the Commonwealth's recommendation is.
Your Honor, Ms. McCusker would plead guilty to assault 4th degree, 12 months, probated for 1 year, supervised, and she would enter and complete anger management classes. And I think she's already she may have those already signed up with cabinet. I'm not sure.
But give me some background, please.
Ms. McCusker evidently had an altercation with her older daughter over babysitting. This is the allegations that's contained from the cabinet. And during the time that they had this altercation, she's supposed to have hit her in the leg with a spatula and cussed at her. That's the allegations of the case. The grandparents who reported this wanted there to be an anger management and didn't want any jail time. And also that's what Sheriff Mark.
Injury?
The picture I've got, I can't make out anything. It's just a red place. If at all, I'll show you the picture I've got. It's by text message. Its quality's not very good. I don't even see anything in that. Yeah. It's my opinion that she probably shouldn't have been charged with felony to start with based on evidence. But that's what she was indicted on.
Is it a probated sentence?
Yes, 3 years supervised. Yeah, no debt.
Yeah,
And Judge, Miss McCusker is under a prevention plan with the cabinet. She is still in.
she reconciled with the child lived with her again, or?
No, I've not had I've not been able to have no contact with her because you wrote no contact. You know, whenever I got out of, I guess for the indictment, and so I ain't had no contact with her. But before that, I was getting to see her and all that, but they said they'd give her back to me today, you know, as long as you said that it would be okay.
How's the child communicating with you? Y'all all right?
Oh, yes. I mean, we talked every day, all that. It's just me and her had an argument because I
How
told
old is she?
11, almost 12.
It'll get worse.
And I usually took her phone away from her, but then I just bought her another phone.
The judge is not wrong. Not wrong at all.
And so.
Do you have any help disciplining her? I mean, it's her father in the home too, or just you?
Just me and her stepfather, but he's been there since she was 9 months old. So it's not, you know, he's always been there, so he's a lot.
And then Ashley, how often are you doing your therapy classes?
Oh, every week. They come every week.
Yeah, well, you ever diverted a misdemeanor to a pre-trial?
Those provided to the statute.
I know, but you know, people do it all.
I know they do it. I kind of like to follow the law most of the time.
I think that some people think there's a plenary power in the district courts to
do that,
you know, but I'll go ahead.
That come back and vacate it.
Okay, I'll accept the plea.
Thank you.
And let me tell you something. Corporal punishment and whipping people is a very controversial thing now. You understand what can happen to you
Yeah.
now over something like this. I'm glad you didn't hurt the child permanently or anything like that. I'm sure there are children all across Clinton County and in Cumberland County that would love to train the punishment that's been put on them for what you did, but that doesn't diminish the fact that, you know, you're gonna have to refrain yourself. And maybe the child will understand too, the repercussions of not minding and provocation. I'm not blaming the child because she's just a child.
Yeah, she's just a child.
Yeah, okay.
This is all coming from a judge who looks like his parents made him go pick his own switch. And I'm sure they did. And if y'all didn't catch it, he was asking the prosecutor, well, he was asking the attorneys if they were considering deferring it down to a misdemeanor plea. And they kind of said, well, no, we're past that stage. And he said, so what? They do it all the time. So the judge really does not want this to be a felony for her.
Okay.
Thank you, Judge.
Good luck to you. Was that supervised?
Yes, Your Honor.
Okay, you'll need to meet with a probation parole officer. Okay, who else do you have?
William Shekels, 23 CR 52.
Cromwell versus William Shekels, 23 CR 0052. Are you William Shekels? Are you William Shekels?
Yes, sir.
I'm born in 19.
Yes, sir.
Last 4 digits, social security number. Okay. Do we have a plea of some sort?
Yes, Your Honor.
What kind is it?
Felony plea, Your Honor. Probation.
So what?
A felony plea, Your Honor.
Mr. Schickel, a motion has just been hindered that says you wish to enter a guilty plea. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Have you previously been identified as the same person named in this indictment?
Yes.
Is your judgment impaired today?
No.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you and are you satisfied that you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea.
Yes.
You have certain rights under the Kentucky and the United States Constitution. I'm gonna go over those rights, and after I do that, I'm gonna ask you if you understand all of them. Do you understand that?
Yes, sir.
Okay, now I may consider the Commonwealth's recommendation, but I may apply a range of sentence provided law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will await a pre-sentence investigation report done by Probation Pro. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and go to trial. Mr. Stockton, will you come forward and say what the Commonwealth's recommendation is?
Your Honor, Mr. Shevels will plead guilty to trafficking and controlled substance first degree, receive a sentence of 6 years. He would be committed to Edgewater Recovery Center in Moorhead, which he's already enrolled in for a minimum of 6 months, and he'd be supervised for 5 years.
Is that what you agreed to?
Yes, sir.
Okay. Are you pleading guilty because you did commit the acts charged in the indictment?
Yes.
You plead guilty to your own free will?
Yes.
Know your constitutional rights, still your desire to proceed with your plea of guilty and allow the court to fix your punishment. You understand that by any guilty plea and future convictions of felonies can be enhanced in a persistent felony offender law. You understand that?
Yes,
Is
sir.
that your signature on the docket?
Yes, sir.
Okay, I will accept the agreement or the pre-sentence investigation report. You'll be back here on February the 8th. Now, was the entire sentence probated? Is that correct?
That is correct. Well, once he completes rehabilitation.
Yeah, but he'll be back in rehab. You leave here today and go back to rehab, right?
And Judge, yes, and we were gonna ask, it was a daunting task to get Mr. Shepard here for transportation. Is there any way he can do final sentencing via Zoom?
I have no problem with that.
Thank you, Your Honor.
You know, or you can go up and get him and bring him back and forth either way.
Moorhead's a little further than Manchester.
You think a lot of, hey, Mr. Shickles, in other words, he thinks a lot of you, but not that.
It's 3.5 hours from here.
I've been there many times. It's a beautiful place.
It is.
I hope your recovery goes well.
Thank you.
Thank you, Judge.
Go to the you drive up the Rocky Atkins Road to get to the Rocky Atkins building and turn right and go up the Rocky Atkins stairs. Okay. I guess we're ready to go back down to Clinton County Jail. Is that correct?
Yes.
Okay. Clinton County Jail, if you'll come on. Okay, let's call Terry Britt out first. Commonwealth versus Terry Britt, 23 CR 0055. Are you Terry Britt?
Yes, sir.
Your year of birth matches,
Yes, sir.
last 4 digits of your social security number.
Yes, sir.
I'm here today for the purpose of arraignment. You have a right to remain silent. Your attorney is here. The grand jury of Clinton County has returned an indictment charging you with possession of a handgun by convicted felon, possession of marijuana, and possession of drug paraphernalia. You understand those charges?
Yes, sir.
Okay. Counselor, you acknowledge the identity of your client, enter plea of not guilty, waive formal reading and arraignment.
Yes, Your Honor.
I'm signing a reciprocal order here, sir, that requires the Commonwealth to provide you with the information necessary to prepare for your defense. You'll be available on January the 29th for negotiations and February the 8th for your next trial, your next pre-trial. Okay?
Thank you, Judge.
Thank you very much. John Brown. Commonwealth versus John Brown, 23 CR 0059. Are you John Brown?
Yes, Your Honor.
You born in 19?
Yes.
Last 4 digits, social security number.
Yes.
Okay. You're here today for the purpose of arraignment. in case number 23 CR 0059, you have a right to remain silent. Your attorney is here present in court. If you have any questions about the proceeding today, he'll be in contact with you. Possession of your grand jury charged you with possession of controlled substance, the first degree, possession of controlled substance, first degree, another charge. You understand what those charges are?
Yes.
Okay, I'm signing a reciprocal discovery order here. You acknowledge the identity of your client receiving indictment, away formal reading and arraignment, enter plea not guilty, reserving all pre-trial motions.
Yes, Your Honor.
Okay, you'll be here in court on January 29th and you're at the courthouse for a negotiation day. And on February the 8th, you'll be in court the next time. If you need him transported for negotiations, it'll be your responsibility.
Yes, Your Honor.
Your attorney will be down to see you. Okay, to explain about the negotiation day. Okay, Commonwealth versus Charles Grizzly. Grizzly. That's the same name as the TV star, Grizzly. Commonwealth versus Chrisley the second. Are you Charles Chrisley the second? I need Charles Chrisley. Thank you. Was Mr. Brown trying to say something else? Mr. Brown, did you have anything else? See, all right. Mr. Brown, I didn't mean to cut you off. I didn't see you trying to say anything. Do you have something else?
Yeah, I was just wanted to discuss bond.
Okay. Have you looked at his bond?
I'm not, Judge.
What is his bond? Yeah, I doubt if you're out in bond and for 100 grams of meth, so you'll probably have to set a hearing on that. I'll be glad to have a hearing. Your attorney will be in contact with you.
Yes, Your Honor.
Charles Chrisley. Charles Chrisley.
Good morning, Judge.
Yeah, hello. Commonwealth versus Charles Chrisley. 23 CR 0061. Are you Charles Chrisley?
Yes, sir.
You born in 19?
Yes, sir.
Last four digits social security number.
Yes, sir.
Here today for the purpose of arraignment. You have a right to remain silent. Your attorney is here in court. He's way there, counselor. See him? Okay.
Yes, sir.
The grand jury of Clinton County returned an indictment charging you with burglary in the third degree, criminal mischief in the first degree, theft, unlawful taking a disposition more than $500 but less than $1,000, criminal trespass, and being a persistent felony offender on the burglary and criminal mischief one. You acknowledge the identity of your client, receiving indictment, away formal reading, arraignment, or plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Setting a reciprocal discovery order, where Mr. Chrisley, where they have to provide your attorney with the evidence, help you prepare your case. You'll be here on January 29th for negotiations and on February the 8th for your next court appearance. If you need a transportation order to transport Mr. Brown, I know he's down here locally right now. If he's here, we'll need to have him brought up probably. Probably need to sign a transfer order or something to have him brought up anyway, okay?
Yes, Your Honor.
Okay, thank you very much.
Judge,
Yeah, Mr. Chrisley, you got something?
could I ask for a bond reduction? I'd like,
Of course you can ask what, just a $25,000 surety.
yes, sir. I don't have anybody to go that surety bond. If I could get a signature bond, get out, get back to work, I'd like to point out that
How much, you have somebody, who you work for?
I work for Detweiler Construction in Elizabethtown. I've been up there.
Surely somebody will sign a surety bond just to get you out. How long you been in?
I've been, it's 3 weeks now, and then I was in 3 months before the indictment came out.
Yes, he had initially served, was released on a 60-day failure to indict and was indicted subsequently. So he had been in a while before.
What do you say?
Your Honor,
Wait
I
just a
turned
second.
myself
Wait
in.
just a second.
I'm sorry.
Be staying in Elizabethtown and working up there.
Yeah. Will you be staying in, what's?
Yes, he's on probation at work.
Yeah.
He's what?
He's on probation out of Gordon County. They had a hand on, but I think they looked at it and put him back on probation. Visitation.
He doesn't have any business in Clinton, so.
Okay, well, here's the deal. I'm gonna lower it to a $10,000 surety. So anybody who's got a car probably come in and sign to get you out. Well, okay, you can't put the car up, but they can show up. But you got somebody that signed a $10,000 surety to get you out?
I don't know that I do, Your Honor. I don't know that I do. I don't have any family left, and I've got a few friends, but I hate to, I'd be willing, like you said.
Wait just a second.
Berkeley third, Your Honor, criminal mischief,
Burglary?
criminal trespass.
What are the fact allegations of this case, Mr. Stockton?
This is the case where he allegedly went in and robbed his mobile home over 50 times. It wasn't being used as a residence, but they were remodeling it, fixing it up, and people going and taking items out of that. And evidently, he's on Hardin County probation, and he was staying down here because he was basically homeless. So I don't know if he's got living arrangements in Hardin.
Where are you gonna live if you go back to Hardin County?
I have a place. I was staying with a friend of mine in Hardin County. And Your Honor, I reported the day after this indictment came out. I knew I was going to jail and reported to my probation.
I know enough. I know enough.
Okay.
I'm gonna tell you what, I'm gonna make a condition on your bond, except for court appearances. You stay out of Clinton County and Cumberland County.
That's fine.
Okay, now I know that's a hard condition to stay out of this area here, but I want you to give a specific address where you're gonna stay. And wherever you're staying, you're to remain in that residence except for work, church, going to the doctor, grocery store. In other words, you're not to be out gomming around, okay?
Yes, sir.
Okay, and I'm gonna lower it to a $5,000 surety bond. Lowest surety bond I've ever set in my life, okay? Now, if after a week you can't find anybody to make the surety bond, your attorney will call the Commonwealth attorney to see if they can reach an agreement, okay?
Thank you, Your Honor.
Thank you.
Thank you.
Okay, Daniel Duval for sentencing. Commonwealth Kentucky versus Daniel Duval, 20 CR 00021. Are you Daniel Duval?
Yes, Your Honor.
Born in 19
Yes, Your Honor.
4 digit social security number.
Yes, sir.
Your pretrial diversion was voided on December 11th, 2023. Have you had an opportunity to look at this pre-sentence investigation report done by probation and parole?
Yes, Your Honor.
Is it correct? Is it correct?
Yes.
Okay.
Yes, sir.
Counselor, is there any reason that this gentleman should not be sentenced?
No, Your Honor, but with regards to the PSI, I think it's just a timing issue. It reflects that the charges in Wayne County were pending. He has been indicted on those pending charges since in Wayne County. And there was an older case showing on the PSI that was also still showing as pending from 2007. We'll check on it.
Okay, it'll be modified. So your reason this gentleman should not be sentenced?
No, Your Honor.
This court sentences you to 3 years to serve. They give you credit for time served. Okay, thank you very much. Thomas Moreland. Thomas Moreland. Commonwealth versus Thomas Moreland, 23 CR 0065. Are you Thomas Moreland?
Yes. Yes.
Last 4 digits of social security numbers.
Yes.
You're here today for arraignment. I see your attorney, Mr. Bertram, is there with you. You have the right to remain silent. If you have any questions concerning thing, you can stop and ask him, could you get, I don't see a copy of the indictment.
They gave me the only copy, Your Honor.
Okay, well,
And I've received that, and I represent him in a plea of not guilty way of form.
he's charged with strangulation, is that correct?
Yes, it is.
And
Second
assault
degree.
is 4th degree?
Yeah.
Okay. Is there any other charge on that, listed on that indictment, Jim?
It says strangulation, 2nd degree, a class D felony. I do not see the misdemeanor. Oh, yeah, I do. Here's the other one. 60.
Those are the only two charges. Do you acknowledge the identity of your client received indictment? Waive
Yes.
formal reading and arraignment, enter plea of not guilty, reserving all pretrial motion.
Yes, Your Honor, I do.
Okay, well, you need to be here on the 29th for a negotiation day at 9 a.m. and back on February the 8th for his next pretrial. I'm signing a reciprocal discovery order. The Commonwealth has information up here that they will hand to you in preparation for the negotiations and for those proceedings, okay?
Well, we did learn that Adair County is back in like 1974, 1976 era. So they may not have figured out computers entirely yet.
Your Honor, we may not need the negotiation day. I think we resolved the case. There's a sentence in district court that's on the obstacle, and that will be resolved on the 24th. So if we could just come back to 8th, I think we'd be ready to enter the plea then.
You come back to 8th, but I want you to have the paperwork done. The paperwork's done. He said, Mr. Stockton says the paperwork's done, so if you'll make sure you have the paperwork here on that day, and if you want your client to be here in court, you'll need to do a transport order to bring him up here, okay?
I'll do that, Your Honor. Thank you very much. I'll be excused.
Yeah, absolutely. Jeffrey Reagan. Commonwealth versus Jeffrey Reagan.
You just wait until I run Lawrence County. Lawrence County, it looks like a church. Like the first several times that I downloaded it, like through the download, I had to pause it and like make sure that it was a courtroom. It was crazy. But yeah, I'm gonna need to run that docket.
0035. Are you Jeffrey Reagan?
Yes.
Can't catch him.
Born in 19.
Yes, sir.
Last 4 digits of social security number.
Yes.
Says you're here on the review. We'll find out what that's about here.
Your Honor, probation and parole. We had a hearing on Mr. Reagan in December, and he had violated his probation, but the court was reluctant to revoke him because of his health. And probation has him lined up for a short-term inpatient treatment at Plea because of his medical issues. And then he'll come out, he'll go through not SAP IOP, but inpatient IOP, I'm sorry. Counseling, if that's all right.
How long is the treatment?
Short term, anywhere from 30 to 90 days.
Okay, is that he had all kinds of medication?
Yes.
And Judge, the only thing Mr. Reagan had asked is, my understanding in doing his intake, that he has to take some items with him, some clothes, some shoes, and some groceries. If he could have some time to go by his home and get those.
We don't have a bed date yet. Bed date's not ready today. We wanted to make sure he was okay with it.
I'm all right with that. I'll go ahead and sign an order, and he needs to get somebody, whoever's gonna transport him. Is it a family member that's gonna transport him? Who's gonna transport him?
I don't know. You all
I don't know.
Well, you need to work that out, and if Mr. Reagan has a family member that's gonna transport him, they can pick him up the day of transport, go out and get the clothes that he needs, and run him by a dollar store. There's one on every corner.
Yes, Your Honor.
Okay.
Yeah, I'll let you know. We'll give him like 2 hours to get there, 3 hours. He's
Yeah.
going to Somerset.
Yeah. Mr. Reagan, do you have clothes at your home that you can pick up Did you take with you, or somebody laundering them for you, or what's the deal?
Yes, sir.
Okay, well, make sure whoever is gonna help you, tell them what you need and that sort of stuff, and we'll let them take you over there and get that stuff and then stop by a grocery. You look like you're feeling better. Are you feeling better?
Yeah, yes, sir.
That's good. Well, I hope you get cleaned up. Things turn around for you, mister. Okay?
Okay.
Okay,
Yeah.
Michael, they'll be getting with you as soon as they get a bed date. Okay?
They talked to me yesterday and told me they had a bed for me.
Well, they'll give you the exact date. Okay? Okay, thank you very much.
Thank
Michael Ritchie. Commonwealth versus Michael Ritchie. Mr. Reagan seems a little bit confused. So,
I was with me, yeah.
Commonwealth versus Michael Ritchie. Are you Michael Ritchie?
Yes.
Born in 19. Last 4 digits of your social security number.
Yes.
You're here for a pretrial diversion revocation. What do you have, Mr. Stockton?
Your Honor, Mr. Ritchie's on, he has a 5-year sentence for wanton endangerment from when he pointed a gun in the direction of Melina Ritchie, who's the victim in this case. I filed a previous motion to revoke pretrial diversion because Miss Ritchie had gotten a plea against him saying that he was holding her and wouldn't let her get to her medical attention. We had a hearing on that, claiming that that was a forgery or whatever. But ultimately, after that hearing, the court ordered that Michael Ritchie was not to have any contact with Melina Ritchie. Well, Mr. Ritchie was arrested on December 18th because he'd been to her residence, had borrowed a car off of her. I don't doubt that he's been having contact with her because since he's been in jail, Miss Ritchie's called me, told me that he's her husband, she's not afraid of him, and she wants him with her because she's having health problems. So the only issue is he's going to be revoked because he violated the court's order, or is the court going to let them have a contact? I mean, that's where we are.
Judge, Miss Ritchie's here. She has been in this courtroom a number of times to dismiss the underlying EPO DVO, to try to dismiss.
Is there a weapon involved in it?
The first because the entry of the plea.
How long has he been in jail?
Over 30 days. This time since December 18th, when he was called down to her residence.
Is she here?
She is, Judge, and we have a trial set on the violations, February 22nd. The allegations most recently are that he was in a car that belongs to him that he has keys to.
There's a district charge for violating the EPO, DVO, and district code. And that's.
Well, I'm just gonna wait and see what happens there. Still waiting, that's the jury's.
What does he mean by that?
You can't say you can't be with your husband, you're gonna be in jail.
I mean, what does he mean by jury?
What do you mean by jury?
So I go to court on Tuesday to have the EPO, DVO amended
Well,
or dismissed.
right, they told me there's a jury trial set for it. Is that correct?
On the alleged assault and violations of the DVO, EPO. Been trying to drop for 6
Well,
months.
I don't care what she's been trying to do. I try to fly and I can't do that on a case. Right now, there's a pending case in district court that's gonna be tried in front of a jury. Now, if you can get the prosecutor to keep the Commonwealth from protecting you, if that's what you want, if you don't want the protection of the Commonwealth, and you want to subject yourself to a continued relationship, there's not much I can do about that, but I'm not gonna do anything until I find out what that jury does or see what the district court does. And I'll probably go along with whatever the district court does, okay? Okay, thank you very much. Joseph Wallace. Joseph Wallace. Commonwealth versus Joseph Wallace. 22 CR 0017. Are you Joseph Wallace?
Yes, sir.
You born in 19.
Yes, sir.
Last 4 digits social security number.
Yeah.
Okay, I'll make that number that change. We're here on a probation revocation hearing. You're representing Mr. Cross. You step to the left, Mr. Cross. Mr. Stockton.
I just briefly tell what the court is. We need testimony. Mr. Wallace has been absconded since June of 2023. And in August of 2023, at the address he was supposed to be living with, Angela Wallace was arrested and she had 45 grams of methamphetamine possession. So that's the two bases for a revocation.
Your Honor, we're prepared to stipulate that he absconded. I believe that
We'll
makes
stipulate and we will revoke the probation, and I guess the time he's got will be good, good time, I would assume, correct?
yes.
Okay, thank you very much. Is there anybody else at the Clinton County Jail that's on our docket here today?
No, sir.
Okay, well, you're excused. That concludes the criminal docket of the Clinton Circuit. Thank you. Porco. Don't, you familiar with the ad?
You want to see your cross turn Grand Road, use good one.
Yeah. Porco. You got to get a judgment for citing that, so. What have you got, Mr.
Your Honor, we were here on the 7th of
Remember
December.
it just like it was yesterday.
I know you do. And the court at that time suggested we try to settle the overall matter.
Good night, Jenny Green. I love you, sweetie pie.
And we have not been able to do so. So I'm back here asking for the court to enter an order saying we can cash the $34,000 check and it won't settle the entire case. I think under the Morgan case, this is what we need to do. And I don't know if we'll ever collect a penny off of anybody else. We may not pursue it, but we don't want to be foreclosed from attempting to do that.
Your Honor, as far as the check and cashing the check goes, I don't know what argument to make on that one. If Mr. Cross wants to cash the check and proceed to try to get a judgment for the excess, I'm sure that we would raise the issue and say that by cashing it, they had accepted the payment. But I think that we're going to have an argument as to the finality of the payment of the $34,000, regardless of whether he cashes it or not. I think.
Well, that's why we're here, settle it now and not later.
Well, let me ask you something. What's your dispute with $34,000?
Your Honor, my dispute is that these funds were paid from the proceeds of a closing. Mr. Little, acting as the closing agent at that time, contacted Porco. From an agent of Porco, received this amount and was assured this was the payoff of the amount that was owed to them. So the check was written for that. So my client, Ms. Capp's client, both have reliance on that statement from Porco that that was the amount that was due to them. I think that would be our defense to anything.
If the amount had been $60,000 and that check was for $60,000, where would the additional $24,000 have come from? Who would have been entitled to those proceeds, and who has those proceeds now that wouldn't have had them if the $60,000?
Well, Your Honor, that was paid. I wasn't there for the closing. I'm assuming that was paid to the LLC as owner of the properties, and I'm not sure how it was distributed after that. I didn't have a part in the closing.
LLC? Did your client own?
My client was part owner of the LLC.
Was your client part
My
owner?
client was part
And
owner
who-
as well.
and who-
Mr. Gibson's client was also part owner of the LLC, and I'm not sure where Mr. Gibson is.
And therein lies the issue too. Of course, I wasn't involved in the divorce action in representing Mr. Riddle because of a conflict, but the issue is, I don't know the time frame of how that agreement was signed relieving her, Mr. Gibson's
Okay, well,
client.
see, this is neither here nor there, Porco. This agreement between these other
Yes.
parties.
But what I'm saying, Judge, is I don't know if that was signed in the course of the closing happening and that was the liability that addressed all of that because they had already gotten the amount from Porco. So that's why I think that aspect is relevant.
Well, do you have any case law that Porco, if they did get the wrong number, Porco did get the wrong number, that it extinguishes any debt over and above that?
Well, I mean, I think when you go
No,
to,
I don't want to know what you think. I want to know if you got any law on it.
well, there's a law as far as the doctrine of estoppel and detrimental reliance.
And again, that's
What's
why-
the difference? I don't see how they would rely to their detriment on that if they receive the proceeds over and above that.
Well, but if they relied on the information from Porco that that was the amount that was due, and they allowed for those proceeds to be withheld from Mr. Little, who was the closing agent, then they assume that debt has been paid and they have relied on that. I mean, that's where the detrimental reliance comes in because they're relying on that closing agent to get the payoff from Porco from the agent of Porco to provide the correct information for the close.
Their action would be against Mr. Little then.
We're not going to pursue Mr. Little. He was in the dark. And the problem was they didn't keep Brett in the loop. They didn't keep anybody in the loop.
Well,
It's not his
I wouldn't
fault.
suggest that anybody proceeded against Mr. Little. But the fact that Mr. Little made a mistake should not keep Porco from collecting their money. I'm just wondering, go ahead.
Your Honor, if I could, I'm not sure that Mr. Little made a mistake. I think somebody from Porco might have made a mistake. But again, that's the
How do you
information.
know that?
Well, I don't know that for sure, Your Honor, but
I have to deal with for sure.
Mr. Little conveyed the information that was given to him from an agent of Porco, and I think Porco's bound by that number that they gave. And I would echo arguments made previously about how they detrimentally relied upon.
What's to their detriment? I don't understand. I mean, they owed the money. If they did owe the money, I don't know that they owed anything. I don't know that this is not the total amount. I don't know. I'm undecided. I hadn't made my decision. But the fact that someone gives you a wrong, if that money, if the proceeds had gone to another party, except the parties that owed the money, and therefore, because of their reliance, the money was not recoverable anymore because a third party had gotten and left it. I would buy into what you're saying.
Well, Your Honor, I think of it like this. If an individual were to go to purchase an automobile, and they were told the price for the car and they paid that, and then with whatever money they had left over, they spent that on their other needs or wants. And then the car company calls back a month later and says, we told you the wrong amount. You owe us X amount of dollars more. Isn't there detrimental reliance on the first number that was told to the
It could
individual?
be, but they were dealing directly with the car dealer and they had a deal on it. I don't think that's a good analogy. It's accurate, but I don't think it applies to this case, but I understand that. And if you had a direct deal with someone, you bought somebody and they said, oh, they didn't charge enough on a piece of land or anything else. But when you have someone that is a closing agent or something and calls somebody and finds out they're closing, I don't see how that creates a defense against the number being wrong from the person that allegedly provided the numbers to the closing agent. I don't know.
Judge, and I think by Mr. Cross's own admission, an employee, which is an agent for his client, is the one that provided that information. I'm not saying we need to pursue.
Mr. Cross.
He did on the record in court.
Your Honor, Tracy Hay answered the phone for Mr. Little and looked on the computer and gave her a figure. That figure was what was simply on her computer. She hadn't been working there long. The difference in all of this, from what Brett's analogy is, and all of these people, we caught it in time. If we'd have cashed this check, I wouldn't be here today. It'd be too late, okay? But we caught it in time because it was an error. It was a mistake. So all we want to do is cash what we've got, and then we'll determine if we want to try to collect off 1, 2, or 3 of these defendants.
How much money is the deficiency?
It's to be determined.
Well, I mean, you can't come in here if you don't know.
Oh, I know. It's about $66,000 total.
More?
No, about 32,000.
32,000.
But as we said in open court last time, I think we would be happy to resolve the case for a whole lot less, but they don't want to pay.
What is a whole lot less? 10,000?
They won't pay.
So they're willing to drop about $22,000 to $23,000 off of what's owed to them. They're only seeking about 10 grand additional. But before they're even seeking that, they just want to cash the check that's already been issued to them. But the problem is, if you cash a check, you're saying that the debt is paid. In this particular instance, there's already like an order that wouldn't be the case, but there, for some reason, they've got it so that they can't cash the check now. It's a whole mess. It's a whole mess.
Judge, I've spoken with my client. It was his understanding that Porco had provided them with that figure. And that's what he thought was the amount that was gonna be paid, and he thought this was all
He
resolved,
didn't
so
know-
he's
he
not.
didn't know, he didn't know how much she owed.
No, because
Who's-
that's the
who-
other
who-
issue.
Who's involved in the management, making decision?
No, the 66K was total. So he's already been paid, what was it, 32? That's why he's willing to settle for another 10K and drop like 22K. So the 66 was a total figure.
What they bought.
Earl, no.
I guess that goes to both of the individuals running the LLC, which is no longer.
Who were
I
they?
think there was an issue with
The
administrative.
individuals in the LLC, Your Honor, my client Joshua Renault and Ms. Cap's client Dwayne Riddle. I do think that Mr. Riddle probably handled more of the day-to-day operations because Mr. Renault is on the road a lot for work. I'm not saying anybody's.
So if I owed, if I owed somebody $66,000 during a close and they quoted 30-something $1,000. And because they made a mistake even before they cashed the check, I'll be able to enrich myself and not pay them for the $30,000 based upon that
No, but
reliance.
that's the other issue, Judge, is they continued to leave that account open and accruing interest once there was some type of agreed order as to what the amount would be for the sale of the property. So then I think you've got to follow the statutory limit on interest that's claimed as well, and we
How
still
much
don't know
is
that.
interest?
Oh, I'd say half of it. That's just an estimate. I have to figure.
Your Honor, the other issue was at certain point, and this is nothing that was ever set in stone agreed on, but there have been discussions about being able to take care of this debt by paying the principal only on it at certain points. Again, there's no agreement to that, but that had been discussed. And so
A lot of people would like to do that.
But Your Honor, I do think that there was a reliance on the part of these gentlemen at this closing that the number they got from Porco was the final number.
Judge, as stated previous.
Should client pay fine?
Brett and I were on the same common ground on this thing. He was supposed to let me know about the closing. We were going to try to determine a figure to be owed. His people didn't tell him, and nobody told me, and nobody told Gary Little. So here we are.
To be frank with the court, I can't say I didn't know 100% about the closing, but I think I did find out the day before. And I already had obligations to be informed.
And I can say I knew nothing about the closing.
So you're not gonna have to chip in on the money then?
No.
If we could just get an order allowing us to cash the check today, then we'll figure it out.
Yeah, well, and here's the problem is that gets you out of it, but that doesn't help me any, to resolve the rest of it.
Well, Judge.
So I will tell you that and give me an order that you have preserved your issue as to whether acceptance of that check is payment in full or not, and go ahead and cash it, okay? Give me an order to that effect, and then we'll reserve. But I'm not saying ultimately I won't rule if that's not payment in full, but you could lose that way anyway. I'll just say that it will not be determinative in my finding on whether it's payment in full. You follow what I'm saying?
I understand what you're saying, but in the interest of economy, judicial economy, then if we don't know that we can collect any other monies on this, why would I want to try to spin my wheels and try to obtain a judgment against these people?
That's why I'm asking y'all what the law is on it. I'm trying to determine, but I can't decide that here based upon facts that aren't really on the record, but just on arguments or no law.
Well, possession is not really a factor in this case because this was proceeds from a sale of a house. So this is what the realtor was getting paid as a chunk. But then the LLC dissolved, and each one of these lawyers represents a different person who had a stake in the LLC, I guess. That's from what I'm gathering. And I could be wrong. Maybe I'm not following it properly. And I promise you, if I'm not, someone is going to say so in the comments. So if there's any question on this case, and you get curious, in a day or so, check the comment section of the replay crew And if I'm wrong, someone will have told me there. I promise you. And I'm not complaining about that fact, by the way. I don't want anyone to think that that's a complaint. I appreciate when I'm corrected because that's how I learn.
But I can tell you that you go ahead and cash that and it will not prejudice you in my decision concerning any delinquency in that account, okay?
Yeah, I do think under that Morgan case, we've handled it the way we were supposed to. We caught it, we come into court and say,
Well,
that's why we're asking.
that's the reason I'm telling you to do an order to allow you to cash your check without damaging your claim for the balance of the account you say is owned. And I'll let y'all take proof on it and submit it, or you can try it on a bench trial, or you can take it in front of a jury if you want to. I can't decide it. I've got no law except, these sort of things on detrimental reliance and estoppel.
So
maybe we ought to put the rule against perpetuities in there too, while we just can't get all those obscure things, okay?
I'll tender an order.
Make sure they see it.
I will.
Let Mr. Little see it too, so.
Mr. Little's not here. Mr. Little's not in the case.
Okay.
So
He's fortunate.
Judge.
Okay.
Yeah, I try during the case itself to keep the comments at least mostly related to the case. Because I've gotten so many comments that say, "Oh, you interrupt the flow of the case," and the most recent is that I'm insufferable to listen to. Apparently, they did not read the channel description, though, that says that this is an interactive chat channel, that we're just a bunch of friends that hang out and watch court cases, and that I do pause and I do stop and I do talk about stuff, random stuff, all kinds of stuff. And yeah, apparently the first beginning intro, our hangout and chat, pre cases time is insufferable. You know what though? I don't mind. Let them complain. According to the algorithm, that is interaction, and that helps the channel grow. Whether you like it, whether you dislike it, if you say something, it doesn't matter what button you push. It's interaction, and it helps the channel. So thanks.
Medical Center at Clinton County Inc. versus Journey Pure.
Morning, Judge. Afternoon, Judge. This is Journey Pure's motion, Judge. As you know, we've been here.
To reconsider.
This is not the motion to reconsider. We've been here a couple times on the motion to reconsider the entry of order. This involves an emergency motion that we have filed, Judge, because they filed a judgment lien.
I'm here for
on
you.
The order that the court is still not ruled on. And that judgment lien has caused our client to actually be in default on some of their other debts, and also has actually hindered us in even being able, if we were to resolve the case, to finance to pay a lump sum because of this judgment lien. They filed the judgment lien, Judge, of record in Bowling Green that's attached now to all of our clients' property, and it's our position. This is not a final judgment. It didn't have the language of finality in it that's made it final and appealable. Also, it had this motion to reconsider still pending, which makes it not a final judgment. We've submitted in our brief, Judge, some law that clearly shows that without a final judgment, you can't file a judgment lien and attach everybody's property. And that is Duval versus Clay. And it dismissed and removed the judgment lien because there were pending motions or motions for relief relating to the judgment that the lien was filed on. And this is our motion asking that this court,
Would you need to file some kind of bond if you wanted relief from execution?
not until it's a final, that you're referring, Judge, to the supersedious bond, that's on a final judgment and you file the notice of appeal, you have to file that bond under that rule. But this isn't a final judgment.
So, and you might very well be correct, I'll reserve till I hear all argument, but let's say I file a judge, I sign a judgment. And then you come in and file a motion to reconsider and put it off to the next rule day. In the intervening time, you get rid of all your assets. Is that a problem? How would they be able to execute on anything if you could never file a lien if there was a motion to reconsider it?
Well, Judge, I think the law is clear.
Well, I mean,
You
I'm just
can't
asking.
file it, that at that point in time.
That's something the legislature need to take a look at, isn't it?
Maybe so.
They could never file.
It has to be a final judgment.
Well, I'm asking you, they could never file a lien as long as there's a motion to reconsider or anything or to set aside.
I think the law is clear on
That's
that.
your position, okay.
That they cannot.
Go ahead. Mr. English.
It's just, Lance, I don't want to. I'll move out, get it out of your way.
Judge, if a motion to reconsider is filed within 10 days under Rule 60.02, Mr. Turner's correct. There's nothing we can do. Got to wait till the court rules on that before we can do it. But that's not what happened in this case, Judge, and that's not the law in this case. They didn't, even though they were before the court at that time, they didn't file a motion under Rule 60.02. They filed a motion under Rule 62, which is a motion to reconsider the default judgment. Their motion to reconsider was not filed within 10 days of the date that the judgment was entered. Therefore, that judgment is final. We do have the right to proceed to file a judgment lien. The court admittedly could reconsider. If you set aside the default judgment, then and there is an order entered setting it aside, then yes, we may have to do something or release the lien. But by virtue of the fact that they didn't timely file that motion under 60.02, we have every right 10 days after the entry of that judgment to go ahead and file liens. And that's exactly what we've done. Judge, all we've done is filed a lien. They filed this motion today to hold me in contempt. Said I've committed a criminal act by filing this judgment lien. And you know, here we're in a situation where Journey Pure, after we have gone through time and time again, let them know of the lawsuit, let them know of the fact that we had this motion, served them with the motion for default, never showed up, never did anything. And then we come in here after all we do is file a judgment lien over and with the Warren County clerk, and they're claiming that I should be held in contempt and I don't know, Judge, put in jail or something.
Well, that could be true, but I don't think over this matter. What's your response?
Judge, his 10-day rule only, that is 59.05. That is a motion to alter, amend, and vacate that we do all the time after a jury trial or judgment. That is where the 10-day rule comes in. It's 59.05 when there is a final judgment. We got to file it for 10 days. We got 10 days to file it. But this is not a final judgment. So that 59 and 59.05 only applies to final judgments. It clearly, the rule says a motion to alter, amend a judgment or to vacate and to enter a new one shall be served no later than 10 days after entry, and the rule specifically says final judgment. So 59.05 and that 10-day rule does not apply because this was not a final judgment. They are the one that prepared the order and sent it to you to sign. It did not say it was final and appealable. It had other parties in this suit that were not even served. So there's no way it is a final judgment under 59.05. That is why the motion was filed as a
Those
motion.
other parties can be jointly and severally liable for a judgment, is what you're saying.
Absolutely.
Well,
And that's what they asked for.
So that doesn't preclude a judgment being effective again in full amount against any one of them, does it?
But it's not a final judgment under that rule because it doesn't deal with all
What's
the
your
parties,
answer?
all the parties' rights.
You wanna jump in this, brother?
This is very eloquent. I'm
Yeah.
just.
I'm enjoying a lot.
CR 54.01 defines judgment, what it is. It does not have to have the quote unquote final and appealable language. It says that a judgment is a written order adjudicating a claim in an action or proceeding. It does, it said all right, it says a final and appealable judgment is a final adjudicating all the rights of all the parties. Now, as occurs Journey Pure Bowling Green LLC, we got a final judgment, Judge. We have it. If at this point in this proceeding we do, and we have every right to protect our interest, and that's all we're doing, Judge. We're not trying to sell property or anything else. We're just protecting the fact that this court.
Did you go after any bank accounts or anything?
No, sir.
But they can once they do that. But Judge, he's blurring the lines there. He read you the definition of what a judgment is. And then he went on to call it a final judgment. When the rule says that the lien, you can't just file a lien on a judgment. If you entered a summary judgment or something like that, unless it says final and appealable and adjudicates all the rights of all the parties, it is not a final judgment. And the rule on judgment liens only applies to a final judgment, that you can only file the lien because you don't want to run around and put a cloud on people's title when you don't have the final judgment, because just as he said, there's still a motion to reconsider pending. He's filed a judgment lien that has clouded all of our clients' property interest in.
How quickly did you file a motion to reconsider? How many days?
From the entry of the written order.
Of the judgment.
13.
So you missed 10 days, if the 10 days apply.
Obviously, I believe the 10 days don't apply. Yes, 13, it was 13 days after the judgment, but it wasn't a final judgment. And 5905 is a final judgment that kicks in the 10 days.
And the statute on judgment lien doesn't say that. It says that if you have the judgment, you can perfect it by noticing, filing the notice with the county, in the county where the property is located.
But the case law that we've submitted, Judge, defines that the judgment lien can only be filed on a final
And
judgment.
that's under a rule where they filed a motion to vacate, alter, or amend following the 10 days. That's what that case held, is that if you've got a motion to vacate, alter, or amend that was filed within the 10-day window, that I can't do anything. It would be inappropriate for me to file that. They filed it 13 days. Granted, this court can set aside a default judgment. I'm not saying you can't, but having not filed it timely, I've got every right to protect the judgment that we have that's on a debt that these guys owe and haven't paid, Judge.
It's greatly disputed on the amount of, if anything, that we would owe. We also have to remember that this was filed really quickly after counsel was made aware of the entry of the judgment. And those motions were filed within days of counsel finding out. It was the discrepancy in regard to the clients and the client's misunderstanding. We've already argued that with the court. But Judge, I would once again say the Duval case.
I really think the judge is enjoying this. I really do. So now that I think the judge is just fishing out all of the things that he's going to have to make decisions on. He's going to have to make a decision whether the 10 days or the 13 days applies, because one side is saying that the order was any motions needed to be filed within 10 days or the order became finalized. The other side is saying, no, that's not true. We filed it in 13 days and we don't think the 10-day rule applies to this. So there's that. And then they have, whether or not the lien can be put on the property, which again boils down to that 10-day or 13-day rule. And I think he's just really enjoying watching these two go at it and make the same exact argument in different words over and over and over again. And Letha May, thank you so much. It does help. It really, really does. And right now, Lord knows I need it. So I really super appreciate you. Especially since I know you're going through your own stuff too, sweetie. So I appreciate that.
Which we have cited to you, which he says it was filed under Rule 59. The actual holding of the case says that where a judgment lien was dismissed by the Kentucky Court of Appeals in this case, when the lien was filed while a motion for relief from the judgment was pending. And that's exactly what is here. We had a motion to reconsider pending before the court when they filed their lien. And Duval, while it was filed under 5905, it was, Mr. English is correct there. The language of the court discusses that it's file a motion for relief from that judgment is pending, and before a court, you can't go file a judgment lien.
Judge, I
Well, I didn't set aside that lien, that judgment, the default judgment, like it was a default judgment.
Yes, sir.
In order to give your client an opportunity, in my own mind, to settle the case. They evidently don't want to settle a case.
Well, evidently they don't either.
Or somebody does, and I haven't heard whether there's been any negotiations or anything.
We have negotiated.
Yeah, I don't know whether any closer to that, but I'm going, I hate to do an order overruling you on the motion set aside, but I'm not inclined to set aside. And I would suggest probably that the next thing that's coming is either a judgment on the pleadings or a summary judgment motion on everybody else. I don't know where you are. You taking proof on any of these other defendants or?
No, sir. In fact, right now,
You think
there
you've got a lien on the people that got the money?
I think I've got the lien on the right entity at this point, and I don't think, just that they have all these different corporate entities and that they're all the same.
Kind of shell companies?
I wouldn't, Mr. Carter's fine.
There is a nationwide debate going on as to what a shell company is, right?
And I'm not going to argue that it's a shell company. I just think we've got a judgment lien. All we're doing is just trying to protect what's owed to us under a contract.
Yeah. Well, I'm gonna overrule motion to set aside the default judgment and also say that because of that inclination, I'm gonna say the lien is valid. So just do an order and then I put final and appealable on that, and you can take it up and you could have a case on that. Okay, thank you very much.
We'll get a judgment. Thank you, John.
Yeah.
Aw, no more grown man hissy fit. Those are kind of fun to watch, though.
Laura Haddix and others versus Nancy Harden.
Oh man, get your bingo cards ready.
Tendered a thought judgment and orders. I'm sorry, somebody's coming around it.
Give me a thumbnail for the record on this.
Your Honor, this is our motion. It's combined indivisibility action and a suit to enforce judgment liens. And we are, let's tender a judgment order, say it.
We've tried to pay him several times and he will not take the money.
Okay, what's your name?
Nancy Hart.
Sorry, somebody called.
Nancy Harden.
And where do you're Nancy Harden and husband Ernest Harden?
Yes,
Yeah,
I have paid some on that.
yeah,
And
well,
I-
you need to speak up.
I have paid on that and I only owe just a little on that.
How much you trying to collect?
Your Honor,
Is
it's
this
far more complicated than Ms. Harden understands.
Um,
Number one, if I may, you
Move
have me
over
with
here just for a second and I'll let you come
Okay.
back.
Number one is the Haddix estate was owed money by Ms. Harden and her sister. Her sister's paid her part. Ms. Harden has paid some. She's credited for all that. Number two, David Cross has a lien on Tony Albertson's part. I want my money. Number three, Stephanie Myers is joined it as a plaintiff and wants it sold for indivisibility. So there's nothing she can do to stop it.
Stephanie said you was shoving her to sell it.
Do what?
Stephanie said that he was shoving her to sell it.
Well, then he.
And are you
he
allowed-
accomplished that then. So,
Are you allowed to?
am I allowed?
No,
Yes,
what I'm
I am.
saying. No, what I'm saying. If you file bankruptcy in federal court, is someone allowed to go in to your stuff and pull that out, your federal court, and put it in these papers?
I don't know what you're talking about.
I don't
I can't
know.
follow what you're saying. Did you file bankruptcy?
We did.
When?
It's been back probably 8 or 9 years.
Was this debt discharged?
It was, but it's in this right here.
Well, I can't read that. It's got
Your
a.
Honor, to go back that far, no.
The $11,000 we filed bankruptcy against, and it's in these papers.
I don't know what those papers are. I can't allow people to come up here and say, in this envelope, it's kind of like Karnak that used to be on Johnny.
What, do
Carson.
you want to see
No,
it?
I don't really want to see it because I can't look at papers and interpret things for you. I mean, I just can't do that. Why don't you have an attorney?
Well, we've tried to get one and no one will go up against him.
Because you have no
They
case.
said
A lot
that
of
more
people.
often.
Yeah.
Wasn't any problem a while ago. Everybody else is up there against me.
Yeah.
Well, I mean, I've tried to pay him, and like I said, he won't have it.
We tried to pay him what?
What I owe
How
him,
much?
whatever he's
How much
asked,
did you try to pay him?
whatever he's asked for.
What do you want this woman to pay?
What? Let him tell
That
me
won't
what he
keep- Wait a
wants.
second. That won't keep the property from
No,
being
I
sold.
think Ms. Haddix is owed around $1,800 now. I'm not sure. We'd have to look at it. It's in the judgment.
But now the property be sold. This lady has an interest in the property, does she?
This lady has a third interest.
Third.
Her sister has a third interest.
Yeah.
Tony Alderson has a sixth interest. Stephanie Myers, Frank
So
Dean's
the
already
property,
said.
you don't want the property sold?
No, I don't,
Well,
because
but-
I promised my mama I would keep it on her
Well,
deathbed.
here's the problem is, that's a promise that would ultimately have to be broken by someone because every piece of property ultimately gets sold. Doesn't it? Sometime it'll be sold. And if there's one person that owns any of it now that wants to sell it, it's not, you haven't broken your promise.
Yes, but I've told him I will pay her for it. I'll pay her
Yeah, but
for whatever she wants.
Yeah, well, then you can buy it at the sale. And see, the thing about it is, if you buy it at the sale, you get your portion of it back. In other words, let's say it brought, what would it bring, Mr. Cross, piece of property?
Oh, it's hard. It might bring 15,000, it might bring 20, I don't know.
Okay, if it brought 15,000, if you bid 15,000, you get your $5,000 worth of it if you own a third of it. Follow what I'm saying?
Yes, but I don't want it sold.
Well, you can't keep it from being sold if one of the parties wants it sold. And I will tell you what happens if is it your sister that wants it sold? Is that who it is?
No, it's my
Her niece, okay.
because he's shoving her to
Well,
death.
yeah, well, she says that now. But that's quite frequently what people say. Well, honey, I would never do it, but that lawyer forced me to do it.
I've
Well,
been
it's
through
not
this bus many
funny.
times. That's fine.
Do what?
I said, it's not funny.
Who's laughing? No, I don't think it's funny. It's sad, but it quite frequently happens. People say that lawyer made me do it. I've seen it happen. So I will,
I mean, I will pay whatever.
well, yeah, but you don't have a choice on jointly owned property.
So buy
Mr.
it.
Cross,
Yes, Your Honor.
if this lady pays her debt, how much are you owed on it?
If you buy it at the sale for the $15,000 to $20,000 that they say it's gonna go for, then you own it 100% and no one can force you to sell it unless, you don't pay the government the tax dues or something for, 3 years? And then on the 4th year, the government can come in and take it or put a lien on it or whatever it is. But at any rate, that's neither here nor there. Just buy the house. Get the loan if that's what it takes. If you're telling him you'll pay any amount, I'll pay his share, I'll pay her share, I'll pay my share. Okay, pay it all and just own it 100%.
Well, I think I'm over 2,500, 3,000.
Yeah, well, and this guy that owes you the money, the defendant that
I
owes
will
you.
pay Tony's part. We told him we would
Your Honor,
pay Tony's
if I may
part.
interject, if you knew how many times I've met with these people and how many promises.
I'm just trying to find out how much, what is he gonna bring up to sell?
I'm done. Okay,
Okay.
I'm done.
Okay, well, you're not done until I tell you you're done,
Well,
so
I
just
know.
come back
As far as
around.
trying to work it.
See, now I'm trying to pay.
Now, here's the thing about it, it's not your debt, it's the only thing that's involved here. That's not your debt. Now, if you got a document that says you were discharged in bankruptcy from this debt, you should have filed an answer and say that this was discharged in bankruptcy. You've chosen not to get an attorney and not to file an answer. There's nothing in the file that you filed. Isn't that correct? You filed nothing. So I really don't have any choice but to sign the default judgment. I don't,
If it's been more
but you
than
can
7
come, you'll be
years,
given plenty of notice of the sale of property and come to protect your interest in it. And Mr. Cross will probably be there and bid $2,500 or $30,000, whatever, to protect his land, right? So somebody else might be there, but I have no choice to do that, but to sign this.
Thank you, Ron.
Yeah. Thank you. Okay.
if her mama wanted, okay, so she's saying she promised her mama on her deathbed that she'd never get rid of the property. Well, if that was her mama's true wish and intention, then her mama would not have given a third to her and a third to someone else, and then a sixth to someone and a sixth to someone else as interest in the estate. Dividing it like that is saying, everybody owns a piece of this, and when it sells, they get their piece. You don't divide property like that just to spread love. No, it is so that when a property sells, everybody gets that amount of a cut. So, if that was her mom's intention, her mama did it wrong. Sorry, it's the truth. And it's a possible but for $15,000 to $20,000, I mean, that's not a 30-year mortgage. It's not. That's what people take out for renovation mortgage or second mortgage or whatever they call that. I mean, I know with my house, they did it on a 30-year, but the house that I purchased was a heck of a lot more than $20,000. But I don't even think that you could get a $20,000 on a 30-year mortgage. Yeah, it's like the price of a car, which would be like $800. Well, no, I'm wrong. A car, if they do it on like a 6-year, but then you got to add in interest charges, and I am not going to pretend that I know how to math and calculate and all that other stuff. All I know is if she wants to keep that property, the only way that she's legally going to be able to is if she buys it. And yeah, it's sad because it's obviously hurting her. And I think it comes down to less about what the mom wanted and more about what she wants. That's the thing. Oh. And I can see that though. I can see why land would be harder to get with collateral. Because there's... when it's land with nothing on it. Even though the land is what has the value. Like, you don't even really know what problems are gonna arise when you start building. If that makes any sense. I don't know what the reason is, but for me, that's what I would think. Because you've got to run water and sewer and electric, and depending on where you got to run it from, that can get quite pricey. And you can run into a lot of complications doing that. So if it's just land, and it's nothing but land, unless it's somewhere that they expect to be developing within the next X amount of years, or unless it's has a farming purpose or something like that, I can see why the banks would be a little leery. Get down. Why do you want to eat the lampshade so badly tonight? What is wrong with you? You want to eat everything that does not belong in that kitty mouth. Earl! If you push the lamp off that counter, I will be very mad. I promise I would be mad. Earl? Chat can't see you, but they can see you. They know exactly what you're doing. Stop it!
Okay, cabinet versus Reggie Boff. Is that right? This is a child support case. What is this?
Judge, this is a divorce case that was transferred here from Rockcastle County in November of 2023.
I don't have a copy of the motion.
It was property.
Did you electronically?
Electronically filed it last Thursday.
That's the reason it didn't get in. We'll get a copy.
Judge, you can see my copy. It's a short motion.
Just tell me what it's about.
Judge, it's a motion for contempt. This is a case where there was a findings of fact, conclusions of law, and decree entered in June of 2013. So it's been more than 10 years. These parties have followed a time sharing schedule for the last 10 years, where she's primary residential custodian. He gets 3 weekends a month due to the distance between the parties. He simply has kept the child and not returned the child to start the spring school year in Clinton County. You know, the child's 15 and a half years old. He's missed the entire first week of school. He's filed nothing to get relief through the court. He's just told her that she's not bringing the child back.
Where does she live?
She lives here.
Where does Tony live?
He lives in Rockcastle County.
And does he enroll the child in Rockcastle County School?
He has, but if you read on the.
No, I'm not asking you what to read anything. I'm just asking you a simple
Yes,
question.
he has.
Okay. Okay, I'd like you to swear your witness and just get somebody. You raise your right hand, man. Your right hand. Your other right hand.
The other right hand.
Yeah, you swear the testimony that you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay, you can inquire.
Ma'am, state your name for the record.
Gina Ball.
And Ms. Ball, did you go through a divorce case with Tony Ball in Rockcastle County in 2013?
Yes, I did.
And did that case go to a final hearing before the court?
Yes, I did.
And were you awarded primary residential custody of the child at that time?
Yes,
And is there only one child at issue?
yes.
What's the child's name?
Braden Ball,
And how old is Braden?
15
Turns 16 next summer.
in July.
Okay, so he's 15 and a half.
Yeah.
What is Mr. Ball's court order visitation that you all have followed for the last 10 and a half years?
He gets him the first, second, and third weekend of every month. He is to get him on holidays every other year. His are odd and mine is even. He got him this Christmas because it was an odd year on Christmas Day at lunchtime. He was supposed to return him one day.
Steve,
I'm sorry.
let's get down to what he hasn't done now.
He has not returned the child. He was supposed to return our son on Tuesday prior to school starting.
And he has failed to do so.
Yes,
And so the child's missed a week and a half of school.
yes,
Okay. And did your court order grant joint custody between you and Mr. Ball?
yes,
And did it also say that if there was a dispute as to a major decision to be made, that your say would go?
yes,
And have you asked that he bring the child back?
yes,
And has he refused?
yes.
And what reason has he given you?
He says that, he has, grounds of showing physical and mental abuse, I believe.
And is this the first you've ever heard of anything like this?
Yes.
Has there ever been any criminal action filed against you?
No,
What did he say that the abuse was?
he did not tell me.
And is there also an issue with is he on some kind of medication?
Yes, Braden takes allergy shots once a week, and he also on Singulair and Zyrtec. And that has not been given to him.
What's his address?
Mr. Balls,
Yes,
612 Flat Pat Road, Berea, Kentucky.
Berea?
Yes, sir.
And are you asking the court to hold him in contempt of violation of the court's order?
Yes, sir.
And are you asking the court to order that the child be returned to you immediately?
Yes, please.
And you have concerns about the child's welfare and safety?
I do.
currently? I think that's all the questions I have.
Child want to stay up there with his dad?
I think they're in the current situation, he's, convinced him to stay.
So the child has expressed to you?
No,
How do you know that he wants to stay?
for text.
I can't hear anything with these doors closing or anything, you know.
I apologize, Judge.
No, it's
for
not your
text.
fault. These closures on these doors don't work like they used to. You know, they used to kind of go. Okay, who told you that he wants to stay up there beside your husband? The father, rather.
That's it.
So you hadn't had the child, you have not had a conversation about.
I have texted him and he has, I've got it on text showing that they. No,
What did he say to you? Either text or calling or phone about staying up there?
He said that he was gonna, that I was to, go home and remain calm and that he
Who's
needed.
this, your son?
No, he was,
I want to know what your son told you about where he wanted to go to school.
is
Either by
not,
text or phone or email or whatever.
is not.
So you haven't had a conversation with the child about you're going to Rockcastle County, Mount Vernon School now? Do you want to
The
come
only
back?
conversation
Well, let
I've
me
had-
finish. You want to come back to Clinton County? Did you ask him that?
Yes,
What did he say?
he didn't reply.
Well, so he doesn't want to come back. Is that what you're saying? He doesn't want to come back?
I'm assuming, or he would be here.
What?
I would assume that.
How would he get here?
Well,
He
it was
can't
supposed to be
drive.
returned.
Do what?
It was supposed to be returned that
No, I'm
Tuesday.
talking about your son. If your son wanted to go to school here, how would he get here? He would call you to come get him, or does he have another relative that transport him?
His father would have to take him since he's a.
And what if the father, and so you're assuming that the father just doesn't want to take him? So the son is undecided about where he wants to go to school?
I'm unaware of that. I can't answer something that I have not spoke with him about.
Have you spoken to the child at all since he didn't?
Through
come back? Let
text.
me finish my question. Is that okay if I finish my
Yes, sir.
sentence? Have you spoken to the child at all about anything since he didn't return on the date he was supposed to?
It has been very brief and very little, sir.
The answer to that would be yes.
Yes.
Okay. Now, this is how you and I are going to get through this. I ask a question, you respond directly to it, okay? So you have spoken to him. And what did he say to you?
That's too difficult, Judge.
He didn't mention at all that he wasn't back, or he wasn't coming back, or wanted to stay up there. He didn't mention anything about it. The little boy.
No, sir.
Yeah. Did you ask him?
Yes.
And he just was silent, correct?
His reply was, Mom, I love you, most of the time, or sending a heart emoji or something to that, or I'll see you soon.
You have anything else?
No, Your Honor, not as far as questioning, no. No, I
Okay,
would
now
just
you want to
simply.
make an argument?
Yeah, Judge, I mean, as Your Honor is well aware, I mean, there's ways to go about modifying time shared custody, and the way to go about it's not unilateral defines of.
Well, I'm thinking that you're entitled to a contempt order. I don't necessarily think it's the best thing to do, but you're entitled to it. There's something else we're not hearing here. I cannot believe that this lady has not had a conversation with that child, or the child won't respond. I'm not saying you're not telling the truth. I'm just saying it's hard for me to believe that the child, if he wanted to come back, wouldn't have said something that he wanted to come back, or I'm happy here. Then he said nothing. I'm not saying that didn't happen, okay? It's very unusual that it didn't happen. When you contact him and say, where are you, Junior? Why aren't you here? And he doesn't say anything about I love you. So I don't know if he did, but we will find out, I would say, when you get an order and have him to immediately return the child. And you give him till in 24 hours from the day he served with this order to get the child back here. Or he should be found in contempt of court, in order to spend 60 days in jail.
Judge, I'll draft an order and tender it.
Okay. Now, if I find out you're not being completely candid with me, it's not gonna be good when I make the ultimate decision. There'll have to be other hearings about this at some juncture, because there's some problem here. I don't know what it is. It's his perception of how you're treating the child, which might be all wrong. Okay? Or it's the child's perception of how he's being treated, and he wouldn't want to talk to you about it. That's the reason it's more complicated. You're entitled to this order. I don't necessarily think it's the best way to go. If you send him a warning letter to bring the child back, or give him any other notice other than this motion?
No, Judge, she came to meet with me Thursday, and that was the deadline to file.
Well, you know, you might very well get the order to me today. And then I would attempt to make some contact with him and tell him to have the kid back down here tomorrow and have him in school.
And I can definitely have her relay that text message.
Well, I don't
whatever
really want her to have to relay that to her child. I don't want her to be the one that tells the child he has to come home.
No, I meant to.
I know, but that's the way it will be perceived by the father. Your mother called up here and says, I have to bring him back. He needs to get a court order from me. And hopefully it won't harm whatever kind of problem you've got with your child. And you got some kind of problem with the child. There's some kind of problem there. I don't know what it is. I hadn't heard it yet, but it's there. Okay, thank you very much.
Thank you, Judge.
Okay, what else do we have on the docket?
She went to the bathroom.
Yeah, the bathroom, late, went to the bathroom.
Yes, my client stepped out, Your Honor.
She gonna step back in?
Oh, sorry. She is returned.
Okay, have her come around. I'd love that. Okay, now this is one that we were gonna send down to the Domestic Relations Commissioner.
That was my understanding, Your Honor.
But let me, before we go down there, see if there's some accord that can be reached. It's not been a day of great accords. Who's got the problem here?
Judge, it's our motion. He hasn't seen his little boy in a year. And he's filed a motion for relief for it because
What's the problem?
Your Honor, the
I'm not
problem,
gonna take any proof. The commissioner will take the proof. Can't work it out.
I understand, what we would say the issue is there was an incident which led to Mr. McWhorter not seeing the child, which was him shooting at my client's belongings, including a Bible.
You doing what?
Shooting my client's belongings, including her Bible, urinating on her possessions, including a childhood heirloom, presumably that would have been passed to their child, and committing domestic violence. So that is what
You
has
get
led.
a DVO on him?
Yes, she has a DVO.
Still in place?
It is, Your Honor.
What does it call for its visitation?
It did not address custody or visitation at all, and Mr. Garman had filed this action. We filed our response back in August. I had expected him to file some kind of temporary motion, but he's done that now. So my client still has concerns that Mr. McWhorter has not addressed his anger problems and has some concerns with his mental state, that he would shoot someone's Bible, urinate on all of their belongings.
Well, I have a
So-
lot of concerns about shooting the Bible. You know, most of them would be long-term sort of thing. I'm not saying he did shoot the Bible. So. Well, it sounds like y'all need to go take some testimony. Have you talked to the commissioner?
I have, Your Honor. He
When
indicated,
can he set a hearing?
that's what he was gonna have us address once Mr. Garman was finished over here.
Okay, well, y'all head on down there.
Thank you,
Thank
Judge.
you, Your Honor.
Orton versus Orton. What do we have here?
Judge, we were here previously and we had entered an order where he would receive visitation with the 3 children, 1 hour per week, supervised by her aunt. And in the order, we had listed that it would be reviewed today.
Yeah, see that.
We are asking that there be no additional visits at this time. And the aunt is willing to continue for another period of time to supervise.
What do you mean, no additional visit?
No additional visits.
Discontinue, that the visitation as it's now in place continue?
Yes, that it continue, but
So
no
when you say-
additional.
Well, when you say that there be no visitation, you could take that as you don't want him to have any visitation. But so you want the temporary visitation schedule to continue for how long?
To stay in place, at least maybe 3 or 4 months. I know Mr. Orton is in drug court and we don't know how long he's going to be in drug court or the status of
Okay,
that.
how are the visitations going?
You want to hear from my client or?
Yeah, I'd like to swear, raise your right hand, please. Swear the testimony best gives the truth, whole truth, nothing but the truth. You get on her side over here. You get on her side. You get in the middle. State your name, please.
Hey there, Danielle Orton.
Okay, go ahead.
The visits are going well, I think. He missed this week's visit, which he said he was sick, so that was fine. I agree with that. The kids don't need to be around that. They're supposed to do it tonight, I think. He missed the first one, but I think it was like communication error there. But other than that, it's going good, but I have concerns with some stuff that he's posting on social media.
Like what? Just tell me. Just tell me.
He gave the kids a phone the last time he was here. The kids have the phone. I have to make them call him, but yet he wants to accuse me of not letting them call him. I'm good with whatever they want to do. He posted something about if people don't quit pushing him, then he's gonna get that IDGAF mindset back. And people's
Gonna
not
get
gonna
what?
like it's, I don't give a mindset, and he doesn't care pretty much who it makes mad. Yeah,
It's
people wouldn't like the
Post
outcome.
that on Facebook or where?
Yes, it's on Facebook.
You have a copy of it?
I do.
That was just 2 days ago. 2 to 3 days
I
ago.
know, Tony.
Yeah, great. I just want to give you.
It had nothing to do with.
Wait a second. Okay, go ahead. Introduce that as, exhibit number 1 for the petition. Go ahead.
The kids enjoy seeing them, I think, but they don't, I have to make them go.
How old are they now?
7, 9, and 12.
Okay, anything else?
Does your oldest daughter create more of a problem in making her go?
She fusses about it, but I know she loves them.
She's 12.
She's good.
I'd say she'd be fussing about everything at 12.
She's got her days.
I just have one other question. Has your aunt reported any other observations in the most recent visit about his interaction or inability to
said-
interact?
I don't know if it's this past time or the time before, but said he was on his phone quite a bit, but other than that, there's not been nothing bad. Said,
Yeah, do you have any questions you'd ask her? I'm gonna let you, I'm gonna let you testify yourself. Wait. But you can ask her questions now. You can't testify. Put her back in the center here. Put her back there. Okay. You can ask her questions now, and then later you'll get to testify. So I don't want you testifying now. Is there any question that you want to ask her now?
Yes.
Okay, go ahead.
Last night, when we had our phone call, when they called, Tessa, the oldest from the 12-year-old.
You're testifying. Ask her a question.
Did she not say she would like to see me more on
I'll-
the phone?
I don't listen to your conversations.
Okay.
They go in the bedroom and I'll go to the
Do you have
living
any
room.
other questions?
Yes. You say you don't listen to our conversations, but you've actually chimed in about the stuff with the Christmas presents and
When you,
stuff. When I was actually-
Wait. I told you to ask her a question. You'll get to testify in a minute, okay? You can ask her a question. Have you intervened in phone calls we've had? Have you talked? You can ask her that question. That's a question, but you can't just take off like this. I'm not gonna have a fussing contest here.
he asked the kids what size they wore. They didn't know. I told them the sizes, they told him.
Okay, now you have any other questions?
No, sir.
Well, okay, now do you have any redirect?
Just one question. Do you feel that the current visitation should continue as it is now for a period of time, as long as your aunt will supervise it?
Okay, here's the thing about it. It's important to have testimony on how somebody feels. She probably feels a lot of things. He probably feels things, but I don't rule on what people feel. If she has any reason why the visitation ought to stay the way it is, or whether it should expand. Now, I call it back up for review. There's no motion here to expand it. We're just reviewing it right now. He needs, as always, needed to lawyer up, which he's never done, if he wants to expand his visitation, okay? So if you want to ask her any other questions, it might give me any reason why I shouldn't expand it or why it should be limited, okay?
Do you feel that it's in the children's best interest that there be more visitation?
Okay, I know what she feels about that. Okay, thank you. Okay, now you can come over here. You come over there, you raise your right hand. Swear the testimony you're about to give us the truth, the whole truth, and nothing but the truth.
Yes, sir.
Go ahead.
Your Honor, I am in drug court. I will be in phase 4, February the 4th or 5th. I'm not exactly sure. No failed drug tests, no failed meetings, always going to my Donna. I've not done anything wrong. I show up, I've tested positive for strep, so I'm just so fair warned. Just like our aunt also missed a meeting and said, hey, can we do it on Thursday? I was over here coughing a while ago. I'm sick.
Well, I'm not impressed by the couple of times you've been this. Don't be coughing.
I know, I'm sorry. The thing on Facebook, Barry Cross is already addressed. It had nothing to do with anything else
Well, it's
other
not
than me
very
getting.
smart to put something like that on.
I was getting threatened for my life.
Well, here's the thing about it is, if you're getting threatened for your life, you ought to go to the law enforcement or somebody else. Because anybody that has any kind of problems, you could take a look at that and use it against you later if something happened to it.
Barry Cross, like I said, addressed it. I can't take it to the law here at being family There's a lot
Yeah,
to this.
you can take it to anybody. You can make a complaint to anybody, whether they're family or whatever. You go to the sheriff's department or you go to the county attorney and file a complaint. Go to the county attorney and file a complaint.
But Judge, it's kind of like the bro code. You know, you can't call the popo on your fam.
Your Honor, last night when I was even on the phone call with him, and I've asked him several times, I'm not asking for overnights, but I would like to be able to. I'm not going to keep them. I love my kids
Okay,
dearly.
well, here's the problem. I'm gonna allow you to at least keep what you have now. This is not gonna be limited, but you need to get somebody to file a motion for you. Okay,
Yes.
it appears to me that
I
you have
agree.
made progress in this
Sorry.
drug court thing. That's what it's about. But you're still a little jacked up, and you get jacked up about your family and that sort of thing, but that will jack people up,
Yes.
okay? So that's the reason that people cannot represent themselves, because it's like asking somebody what minor surgery is. Minor surgery on somebody else,
Yes, sir.
somebody else's kid. Visitation, with your visitation, and the fact that she willingly admits that the children still enjoy being with you. You know how much blessing that is for you, that after everything that's happened, that these children still want to be with you. You know why? Because children naturally love their parents even when they don't deserve to be loved. So what you need to do, rather than try to come and argue this yourself.
That's it. It's Becky D's fault because we did not all hear it so intensely until she said that. No, I've heard it the whole time, and I'm really sorry, but there's no way that I could remove it. I'm sorry. I love you. Please forgive me.
Is get a lawyer and let the lawyers work with Miss White and the mother to see if y'all can gradually expand these visitations back. And when you get finished with drug court, keep your job, things turn around, you chill a little bit and everything, that y'all can live your separate lives and co-parent these children. So I'm not gonna give you any more visitation today because I don't have a motion from you, but I'm not gonna take any of it away from you either, okay?
Can I say one other thing
If
about
you
this?
want to, you're
With the
probably better
article,
off
they,
than not.
well, I mean, with the article, like they turned in for evidence a while ago.
Yeah.
I have blocked her, my family, her whole family. In my opinion, they need to quit stalking me. I get comments, I get things.
What do you mean
all the-
stalking? What do you
Well,
mean stalking?
I have her blocked on every social media, Snapchat,
Well, here's the
everything.
thing about it.
Yet they keep,
Somebody sees something like that. I want to know if the father or mother of my child was putting something up there, especially if I was concerned about him anyway. So maybe a relative or somebody sees that and sends it over to him. It would concern me on whether my daughters or children were going to come over to see you if you putting stuff up there like that. So I better not see more of it. Just keep it to yourself, man.
one more thing.
Yeah,
It's just
well, you're not helping yourself. but
no,
keep
this
on
is
going.
about our visitation, Your Honor. I know I'm not supposed to be within 1,000 foot of her. She's coming in early to our visitation and sitting in the parking lot, McDonald's, Majors. I don't want anything to be used against me. Can her aunt please inform her when her
Well,
visitation's
I
over?
want to tell you, if you're at the McDonald's and she pulls up out the parking lot, and I'm not gonna say anything about that, it's okay.
I just don't want charges against me. Your
Well,
Honor.
have you been pulled up McConnell? It's okay.
Like, I don't do anything. I sit there and I make it.
Okay, well, that's okay. Just don't worry about that.
Okay, I just don't want to get.
Well, that's one thing that you don't have to worry about.
All right, thank you, Your Honor.
Okay, now you can go ahead and leave.
Okay.
And we'll you get a short order that the visitation as is will continue for 3 months, 3 months, okay? Okay, thank y'all very much.
You want me to put a review date or just say, and it may be brought back?
The rule, let's come back on April the 11th. See if we top it over, okay? Hey, let's go off the record.
I want to look and make sure.
Well, there you go. A 2.5 hour docket of Kentucky that had arraignments, had the grand jury, it had property settlement cases. It did have some child support ones, but they were so boring. It was literally, what does this person owe? When do they start paying? Pay them. That was it. So I cut those out. And then let's see, we had counties that were stuck a couple of decades in the past. Relationship issues, everything. This docket had everything. I kept trying to find a spot that I could, seamlessly stop. And I couldn't find one, every section of the docket had something so good. But as you could tell, I had to babysit the entire docket while editing, because they did the socials and the birth dates on the arraignments, and they did addresses, and I missed one address and the whole thing. But yeah, I won't. But when I got up to go potty the last time, I grabbed something. And I want to show you. I've talked about this before. But somebody is asleep, right? Like out cold. Oh, it's the one time she's not going to do it. Are you kidding me? Oh, thank you. Thank you so much. I wish I could see the super stickers, but I just see that it says super sticker. If I was to open it up on my phone, I probably would see it. But Ava, how come you don't respond to cheese when you're sleeping anymore? You used to be so good about it. You used to be so good about cheese when you're sleeping. It's your favorite food. It's your favorite. Can I get a roof? Can you speak? Can you speak for cheese? Speak? Speak? She's like, I would, but I want the cheese too bad. Too much. Cheese, cheese, cheese. Oh, Earl spoke. Good catch. Oh. See, I am in sync with my chat. Chucks and Cherries and I are synced up. You and I got it going on. Yep. You're right. Sometimes I think she don't even taste it. Yeah. Earl's been just a handful. Oh, he's back down on the floor, licking the carpet. Earl. Come on now, buds. I don't get you today. You're seriously licking the carpet. What is down there? What is down there, buds? They're the best. I love them. All right, guys. Now she's responding to the crinkle. That was it. There was just one. This is just the wrapper. You don't eat wrappers. I'm sorry. I'm sorry. Come here. Get back up there. They can't see you catch it from down there. Come on, get back up. Back up. Whoa. Oh. Or this. Or this works too. This is okay. This is all right. It's your good girl. It's your good girl. Look at that face. Look at that face. That pretty buffering face. I want everyone to see your freckles, but they're on this side, and you're always... Maybe I gotta turn my chair around and have you come over on this side. That way everybody can see your pretty freckles. But now I'm probably blocking the lights worse. Come on up. Come on up. Oh, okay. That did not go as planned. Okay. Come on up. All right. Oh, stop. I want everyone to see your pretty face from this side. Because look at how beautiful you are. Look at how beautiful you are. My good girl. Now you've got lots of treats in your belly. Lots of treats in the pretty girl belly. You are so sweet, Ava. Mama's sweet angel. I love you. Well, I guess I'm technically grandma, but I'm mama. Thank you again, Debs, and you have a wonderful night, sweetie. I love you. I know. You want to get rid of me. The truth comes out. It's always telling me to go to bed and say goodnight. Yeah, the truth comes out, you know. Everyone else wants me to stay forever. Philip He's trying to get rid of me. Everybody, I'm going to go to bed and you need to blame Philip for it. Aww. Ooh, have a good night, Chadaskadam. I love you. Good night, Letha May. Love you. Good night, my mama jamma. I love you. And I love you, Tammy13. And I love you, Philip Heels. And Billy loves you all too. All right. Be safe, be well, sleep sweet, and much love.